Hey everybody, I'm finishing all the SEO stuff for a video I'm about to drop, so feel free to comment and I'll respond. We're just waiting on Pisco. We got about 15 minutes, but I thought I'd pop in anyway. Give me just a second. Hey Fox, hey Kalina. Said we've got about 12 minutes and then Pisco will be here and we're going to talk the 14th Amendment and Trump. Hi, World Peace. We have World Peace. World Peace is here. I brought us World Peace. You're welcome. All right. New video went live. Let's see. You said my dog's name correctly. That's good. I'm glad I pronounced it correctly. Why can't I? Good evening, Drummer Cat. Hey now, long-haired lefty. Said we're waiting on Pisco to be here. He's an attorney. He's a good buddy of our mutual friend Destiny's. I'll be honest with you. I don't even know. I always feel strange like explaining who Destiny is, given that he's like 10 or 11 times my size. But I don't know like who all is from that community. Like, and my grandmother watches this. My grandmother's, 86 years old. She has no idea who the hell streamers are. So I always feel like I've got to clarify. But super strange because it's like a F tier quasi celebrity explaining who Tom Cruise is. So weird. Let's see. Hi, everybody. Getting all the documents ready. Like I said, we technically start at 8, so in about 10 minutes. Perfect. 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 I think we got it. I'm going to share a screen. Can you all see this? Veronica Sawyer. Hi, Grandma. Long hair lefty. I barely know who you are, let alone the other guest. Well, right now, the other guest is a figment of my imagination, but he will be here soon. Kalina's agility partner says, I actually have agility in about 10 minutes, just watching videos till then. Cool. Appreciate you stopping in. Cool. I subscribe to your podcasts. What do you say? I subscribe to your podcast, but come back. You have the live stuff down to a science. Boring. Well, you'll be missed. Damn. Long haired lefty says, I really like your lighting. It's calming. I appreciate that. It's like very therapeutic. It's like a scented candle, but for the eyes. Let me send this link. Cool. All right. So we've got everything up. Like I said, guys, we're going to be talking about Donald Trump and the 14th Amendment, which is about as fascinating as a thing can possibly be. I think it's about as sexy a topic as you can get. Annoyed Dragon, LOL. People are awful sometimes. I'm sorry. I've enjoyed watching your post from it. People are definitely blunt or can be in the comments section, both on live streams and in videos. But I actually like to engage with it. Like one of the things I get the most is on my videos. A lot of people, not like a lot in the grand scheme of things, but a surprising number of people are like, just play the clips. Don't give commentary. It's a commentary channel. If you want the clips, go to Fox or C-SPAN or MSNBC or whatever, you know. Bill says, I'm still going to watch your podcast, dude, because I love your perspective on everything. Well, I appreciate that. Like I said, it's not that the live stuff isn't down to a science. It's just I logged in early to get everybody, like to start the thing early, give Pisco some time, rather than just starting right on the dot, which is a recipe for disaster if you've ever live streamed before. Kathy, hello from Virginia. Hello from Portland, Oregon. Let's see. I stumbled into your videos, onto your videos, and I've liked everything so far. I just caught the end of last night's. Yeah, I appreciate that. That one also generated, I don't want to say a bit of controversy because it really wasn't that big of a deal. I genuinely and generally don't live stream because it's very mentally taxing. Um, so I generally do just like pre-recorded stuff. It's improvised, it's not scripted, but it is pre-recorded. So in case I, get halfway through a video and just have a complete like, I don't know, mental lapse, I can delete it and start over. I tried live streaming a couple of years ago and I didn't like it. And I don't play video games or anything else, so it's not exactly visually appealing besides myself. Um, but yeah, so I enjoy occasionally having conversations with just with people. So like today, we have Pisco, who is an attorney. He's a very progressive attorney, very liberal attorney. So it's not going to be an adversarial conversation. And he's going to walk us through the breakdown of the interaction between Donald Trump and the 14th Amendment. Yesterday with PF Jung, he's a self proclaimed enlightened centrist. And I like the guy. I like bantering with the guy. He's cool. I despise his political opinions for the most part, which you could probably tell in the conversation. But I think it's important to engage with people on political opinions, certainly on Trump, and certainly with someone who I think is genuinely a good faith actor, which PF Jung is. So him saying that he's Trump curious, we had to correct that. I'm sure we'll be addressing it again. Basket case, is this where we're holding the Jessica Tarlov fan club meeting tonight? Of course, Her Majesty. I just dropped a video about her, as a matter of fact. She's the gift that keeps on giving, certainly for views, but also for the soul. So when you cover electoral politics, and hopefully none of you obsess over it to the extent that I do, because it has made me a profoundly unhappy person. Not really, but kind of. So she's actually kind of like a tonic for that, because it's so good to see her walk into the lion's den on Fox News. She's outnumbered 4-1, and she kicks ass. She does so freaking well, pushing back on their nonsense. Pisco says hi. We'll jump in shortly, so he's gonna be in just a few minutes. Long-haired lefty says it seemed like friendly hostility. It was. It was. So again, I like kind of like rough and tumble verbal interplay. Like I like that. I like being able to go F you, no F you over something about which you're passionate, and then shake hands and then, go grab a beer or something like that. I think that's important. Because I'm animated by this. This isn't performative. Politics. I'm much more emotionally invested in the 2024 election than I probably should be, given that I'm not really a member of a marginalized group or anything like that. It's not like I've got a ton riding on it, but people I know and even total strangers do. And so, yeah, it's really important. So definitely, I get excited about debating and talking politics. Whereas if it were like anything else, like I don't know, sports or whatever, it's just like, yeah, whatever you say. Timcast, appreciate it, man. Super chat. Love the format with the video up front. Hashtag Tarlov. Yeah, so I'm experimenting with that a bit. So here's the thing. I still currently have a day job. And I actually have a second job too, writing articles for our mutual acquaintance, Luke Beasley, who is killing it. 209,000 subscribers. He was 30,000 subscribers this time last year. That guy has, the gift and the diligence and everything. And he's just grinding. And he has a website, lukebeasleyshow.com. And there's a news section, and I write 3 articles a day for him. So I have a day job. I have that job. And then I do this. I try to put out 3 videos a day. And it's a lot. It's a lot. So I usually don't have the time to do any grandiose editing, but I've been forcing myself to make just some little tweaks here and there just to test the formula, see how it's going. And yeah, when and where possible, I will try to start putting some of the clips up front, and then add additional context and the fuller clip later. So appreciate that. Yeah, I don't watch the news. I watch you. I appreciate. So again, I appreciate that. This is not a and this is something I try to be upfront with. This is not a news channel. I do not pretend that I am some sort of unbiased, disaffected, unaffected I'm not a journalist. I'm a commentator. I have a political science degree. I've always been a politics nerd. And I have my biases and I have my perspectives. And I just think the difference between me and someone else, not everybody else, but other people, is I can defend my biases well. It's kind of like use a I don't know if the Yankees are still like the top baseball franchise, but obviously that was the meme growing up. I don't watch a lot of baseball. But if you're a Yankees fan and you're like, the Yankees are the greatest baseball team ever. Well, you are both biased and telling the truth because they're not mutually exclusive. And that's how I view things. I'm biased towards the progressive left, but I think the progressive left is more correct far more often than not. So Luke Beasley is awesome and way braver than he is incredibly brave going to these Trump rallies. Jeez. I mean, I'm not listen, I think it's a cult. I mean, it is a cult. It's not a matter of opinion. Cult experts regard MAGA as a cult. I have members of my family and friends of mine who are in that cult. They're not necessarily the treasurer or the sergeant at arms, but they're in the cult. And I trust them, but that's also because we have a relationship, right? Luke is a guy with a microphone who is asking tough questions of cultists who I assume I've never yeah, I mean, I assume who have been drinking at various points even because it's almost like tailgating, right? These political rallies. So yeah, he's definitely putting himself at risk, but he's good at what he does. Fortunately, I'm aware and have been warning people Project 2025 is a blueprint for losing our democracy. 100%. Yeah. So, and this came up yesterday in the conversation with PF Jung. Um, Project 2025 is really, I don't want to say, I'm not saying it's entirely new because like the notion of like unitary executive theory on which Project 2025 is predicated, this idea that literally all executive power in the United States resides with one person, the president. It's been around for a while. Conservatives have held that view for decades. Many have. Bill Barr, Donald Trump's former attorney general, under George H.W. Bush, um, the elder Bush, the late elder Bush, he held that belief. Right? It was very common in the Reagan administration. But to see like this really, I don't want to call it a Bible because a Bible sounds like graceful and angelic. It's almost like a grimoire. It's like some sort of like satanic spell book of fascism. They put pen to paper. It's 1,000 pages long, and it's just like this intricate play by play of how they're going to radically reshape the federal government. That's terrifying. Hey, what's up, Arian? Good to see you. Hope Pisco will cover if there's a difference between putting Trump on the ballot for primary in comparison to the general. If you stay, you can ask that question. That's part of the reason why we're doing this live is not just for me to ask questions and play the devil's advocate, because obviously Pisco and I agree that Section 3 of the 14th Amendment disqualifies Donald Trump from holding office. We think that that is a clear, honest, good faith reading of the Constitution. And so, because we don't have somebody in this conversation who disagrees, I will be asking him question as a poli sci major, as somebody who studied poli sci but didn't go to law school, right? So, even though I'm relatively well informed of the Constitution, he's even more so as a matter of law. So, like, I'll be asking him questions, maybe teasing things out by playing the devil's advocate. But if any of you have questions for Pisco, the expert, when he gets here, you absolutely can ask. What's your opinion about Mother Brain Trump wanting to impose a fascist totalitarian dictatorship on the country with Mother Brain Trump as the absolute ruler? Terrifying. Absolutely terrifying. I'm happy to see that the media seems to be increasingly willing to use the F word to describe Trump, which is fascist. There's still quite a bit to be desired. A lot of people will say, well, fascistic tactics or authoritarian tactics. It's important. I think the media is becoming slowly but surely, because if you look now, a lot of outlets are starting to cover it. They probably should have done so at the beginning, but it's important that it's generating the pushback that it does. Under George W. Bush, they gave him unitary power under the Patriot Act. The president could extraordinarily render you to a black site and torture you. They would never allow. So, Jeffrey, what's hilarious is the double standard you just identified there. That's something I harp on all the time, because I think, generally speaking, when it comes to like assigning powers or responsibilities or things like that, a good thing to do is always to imagine what if what you're talking about was imposed on or in the hands of, depending on if it's a responsibility or a power, the other team, the other party. So, when there's Pisco right there. There he is. Hey, what's up, buddy?
Hey there. Can you hear me?
I can.
How you doing? How do I sound?
You sound wonderful. Is there any way?
That's great.
Can you I'm so far above you right now. Do you see this?
Oh,
do you see this right now? You're
yeah,
your head on my shoulder. It's actually kind of cute. It's romantic.
Is that better?
That's better.
A little bit.
Yeah,
Okay.
we make that work. We make that. I can actually, if I'll tell you what I can do.
Look at that. We both have
desks. Desk a little bit.
We both have standing desks.
Yes, we do.
It's important.
So it is, man. I'll be honest with you. I don't use the standing function quite as much as I probably should.
I get the rings in. I don't know if you have Apple products, but
I do
for my watch.
For my phone, anyway. I have a phone and an Apple Watch. Yeah.
And it'll remind you too. It'll be a little bit sinister
aggressive
or nagging. Yeah, passive aggressive when it's, you slacked off yesterday.
No, yeah, it's definitely nagging. There's no doubt about it. Can everybody hear Pisco well?
I hope so. Hi, everybody.
Hi. Okay. So we're going to jump right in, buddy. And I'm sure people are going to have some questions for you.
100%.
But I didn't. Wait a minute. Why is this? Say something now, Pisco.
Testing 1, 2, 3. How's that?
Okay, that's good. I think you sound great on. Say something again.
Hey.
All right, I'm gonna crank it up just a little bit. All right, you're louder in my ear now, which is good.
Okay, that's good.
Okay.
Oh wait, I'm being told wrong mic. 1 second. I think this is the correct mic. I'm hitting this. Can you hear it?
Yeah, I can hear the pop.
There we go.
Okay, good. So listen, man, here's what I was thinking. You and I talked about this months ago, possibly doing this. And then the Colorado court made its decision. We both thought it was terrible. It was appealed. Opening arguments, I understand, were today. I did not have a chance to listen to them. I know you shared the link on Twitter. Hopefully, it's not necessary, but hopefully you got a chance to listen to at least some of them.
I listened to a lot of it, yeah.
Okay, cool. So here's the situation for those who don't know. Obviously, it's a major topic on my channel, and Pisco, who is an attorney, and he can introduce himself in just a second. So Section 3 of the 14th Amendment, and we'll actually look at the text, and Pisco will use his lawyer brain to analyze and interpret it for us. My layman's understanding as someone with just a poli-sci degree, Section 3 of the 14th Amendment was ratified after the Civil War, 1868, and it was intended to keep insurrectionists who'd taken an oath to support the Constitution from ever holding a constitutional office, public office in the United States, because they'd betrayed the Constitution. They couldn't be entrusted with that level of power. And so the argument is, well, Donald Trump took a constitutional oath. We'll address that at some point, because obviously some people quibble over it. And he betrayed the Constitution by either engaging in insurrection or giving aid and comfort to those who did. Therefore, he is not eligible to be the president of the United States. Now, before we break it down, Pisco, do you think that's a fair assessment of the question?
Yeah, I think that's a fair assessment. This is a case, the first case to reach the merits about Trump's qualification for the office of president. And it's interesting for a lot of procedural and substantive reasons that we can get into. But at base, it's assessing whether or not he's qualified under Section 3 of the 14th Amendment.
Okay, so before we jump into that, you can tell us about as much about yourself as you want, but obviously those in my audience who know Destiny obviously know you, but I also have people who have no idea what the streaming world is. So if you could clarify who you are, what your background is as far as the law, establish that you're not just some ruggedly handsome fella opining about things. You actually
Well, listen,
have, yeah, some expertise.
I don't claim any special knowledge in the realm of like constitutional law. I'm a lawyer. I passed the bar. I've been in practice now for a few years, and so my expertise on this issue really is just reading the briefs and arguments from petitioners in this case, understanding, reading the academic papers that kind of sparked this interest both in the litigation field but also publicly. And so I don't claim to have any profound knowledge about the sort of narrow, specific constitutional issues, other than me just referencing and thinking about the arguments that the practitioners in this case are using. But I am a lawyer, and so I'm able to understand some of these arguments and hopefully digest them for those of you who have an interest.
Fair enough. All right, so then we'll jump into obviously the basis for all this, which is Section 3 of the 14th Amendment. Now, I'm going to share a screen, and I'm going to say something. I want you to say something. I want you to tell me, do you hear an echo?
I do not. No.
Okay. Does anybody else hear an echo? Okay, I'm going to assume you don't. If you do, let me know. So here we have Section 3 of the 14th Amendment. Now, I'm actually going to let you read it, Pisco, because
Sure.
when I do this, sometimes like the clauses, I won't emphasize things correctly, so it sounds like a jumbled mess. So if you want to read Section 3, which is the basis for this.
So this is Section 3 of the 14th Amendment, which, to give you guys some background, the 14th Amendment is one of the Reconstruction Amendments. It's a very important amendment for current constitutional law. The Equal Protection Clause is in Section 1 of the 14th Amendment. The Due Process Clause, which applies to states, is in Section 1 of the 14th Amendment. The citizenship at birthright citizenship, is in Section 1. So it's a very important amendment that was passed after the 13th Amendment, and this is Section 3, obviously after the Civil War as well. And it says, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability.
So the first thing I guess I want to ask you is they use the phrase, or the Constitution in Section 3 uses the phrase disability. Now, I've heard legal scholars say that is a very key word in Section 3. Do you agree? And if so, can you explain why?
Yeah, it's a key word because a big problem with a lot of the arguments by Trump and his defenders, or those who disagree with the position that he's disqualified or that this could disqualify a president, is essentially that they have to find a way to distinguish this disability, this qualification, from other qualifications where we would feel more comfortable disqualifying someone from the ballot. Say, for example, the Cenk Uygur case, where he's running for president, but he's not a natural-born citizen of the United States. Or Barack Obama, who has already served 2 terms and obviously is ineligible to run for president on a 3rd term because of the 2-term limit. There are a bunch of qualifications that people feel pretty comfortable in applying to the president without much kind of procedural requirements, or maybe without Congress's involvement necessarily. And so one of the arguments by Trump and by others has been that this is not a qualification for president, like age or like terms in office or like natural-born citizenship. It's a disqualification or disability that needs to be imposed actively. And so it requires some additional layer that doesn't operate like the other, quote, qualifications of the Constitution. And so I don't really buy that argument. We can get into why. But having and cementing the distinction of disability versus qualification, that's a dichotomy that I understand to be an attacking point for the Trump side.
So you juxtaposed it or compared it to things like the two-term limit imposed, the two-term limit imposed by the 22nd Amendment. You also mentioned like the natural-born citizen requirement, the age requirement. You have to be 35 years old to run for president. I have heard the argument made that this is as automatically disqualifying as being 28 years old and trying to run for president, or running for a third term, that this is actually similar in that respect. So just to clarify, do you think being an insurrectionist or giving aid and comfort to insurrectionists is as automatically applicable as a disqualification, as rendering you ineligible for office, as being 32 years old, as being a foreign-born citizen, something like that? Do you lump these things together or not? Do you think there's any meaningful distinction here?
I don't think there's a meaningful distinction, and I do think that they're automatically, quote, self-executing. What you're referencing is this notion that we're dealing with of self-execution is there doesn't need to be somebody or some congressional committee or any particular court to disqualify someone for being too young for president. It just operates. The implementing function or the implementing method to prevent someone from accessing the ballot, being a president, is the Constitution itself. That's what disqualifies you, and you don't need something else, right? That's the automatic nature of it. And I think that on balance, the history and purpose of this clause shows clearly that it's meant to operate in a similar way to these other self-executing qualifications.
So what do you say to people, though, who are like, okay, listen, it's much easier for anybody, either the person in question, other people, to determine whether or not you're 35 years old as opposed to whether or not you're an insurrectionist. So like the fact of the matter is more easily discerned. And number one, do you accept that? And number two, if you do accept that, doesn't that, even if it's not said in the amendment, doesn't that necessitate there be some fact-finding body to make a decision?
Yeah, so I accept that it is a harder inquiry, both in terms of fact gathering and application, to determine whether someone engaged in insurrection or gave aid and comfort to the enemies, than the factual determination and application of your age of birth. I agree that as just a matter of logic and practicality and what these words mean and interpretation problems, it is more difficult to apply Section 3 of the 14th Amendment. But is that a distinction with a difference? You know, there could be it could be easier to determine someone how many times they've been president than it is to determine how old they are or where they were born. There are a lot of different constitutional provisions that may be easier or less easy to apply in different areas. But absent some clear textual command to the contrary, or some clear structural part of the Constitution that prevents that interpretation, I don't think that just the ease of application is what distinguishes or should be used to distinguish those different qualifications. And you can think of a bunch of examples or fact patterns where it might be difficult to ascertain someone's true age or their place of birth, where there would have to be some fact finding involved. And so
you could falsify a driver's license or a form
correct.
of ID. Yeah.
And so assume that someone came with an allegation and said, I understand that Barack Obama says he was born in Hawaii and he has his birth certificate. That's a false one, right? And under that, and let's assume that there are other procedural problems and hangups which exist in a lot of these cases, including the Colorado case. Let's say that they're fulfilled. In that case, there would need to be some fact-finding done about whether this is a true birth certificate or a falsified one. And so there could be fact-finding in any of these qualification problems, and there would be. Also, most of these proceedings will be appealable to some court, either the state court system or the federal court system, which will have ultimate review, either for clear error or for de novo review of any kind of factual determination or legal conclusion by a non-court or a non-lawyer or whatever parade of horribles in terms of the assessor that the Trump campaign is trying to bring up, that it's so wrong if it's just the Secretary of State were to do it. All of those problems would be obviated, I think, by the fact that this would be judicially reviewable.
So when it comes to the assessor, now I'm not familiar with literally every state's procedure, but my default assumption is that it's somebody in the Secretary of State's office in each state. So in a situation like this, I know you said it would and should be reviewable by the court. Do you think the state's executive branch or the state secretary of state should have any role to play, or should it just, if there's a question about whether or not a person is an insurrectionist, should it go automatically to the court, or would you make room for that being a determination that the secretary of state makes, and then if you want to appeal it, you can? But do you make room for that extra
Mhm.
layer?
Yeah, I think that that's a question of state law and also federal law to the extent that Congress were to ever pass an implementing statute related to Section 3. Obviously, Congress has the authority, if they wanted to, under Section 5 of the 14th Amendment, to implement some method to enforce Section 3. But I think that ultimately that's going to be a determination that they have to make. Um, for even in this case, for example, there are some issues about whether state law actually allows this kind of lawsuit, either at the stage of remember, this is a disqualification from a primary ballot, not a general election ballot, and so ultimately, I think that that's going to be up to each state to do. Do I feel comfortable with the Secretary of State being the last word on whether a president is or is not qualified? No, of course not. That was just one person determining, if they wake up on the wrong side of the bed, they'll say one thing. If they wake up on the other side of the bed, they'll say another. Although, keep in mind, some people make the same accusation of judges.
Sure.
But ultimately, I think all of those decisions, if state law were to endow that authority into one person, that would be reviewable.
Okay.
Even in those cases, I think that there would be always some forum that the disqualified candidate could appeal to, so that they're not at the whims of whatever state executive official is disqualifying them.
Who's either a political actor or a political appointee. They're either appointed by the governor or they're independently elected as well. So I understand that.
Sure,
Now
and,
you
and a lot
mentioned
of these. Go ahead. Sorry.
no, please go ahead.
A lot of these executive officials are reluctant to use this authority,
Sure.
even in Democrat-controlled states. And the inclination, I think, by most people has been to channel it through the courts. There are
Yeah,
some states.
Jenna Griswold,
Exactly.
Colorado Secretary of State, a Democrat, a political actor who does not like Trump and does believe that Donald Trump is a threat to democracy. She has been loath to touch this with a 10-foot pole. As a matter of fact, wasn't she? I don't want to not a litigant. Wasn't she one of the parties in the suit that?
She's sued.
Yeah,
She was
yeah,
sued. She's a she's not the party in interest, because ultimately that'll be Trump. And Trump is the one who's going to be pushing, and the Republican Party of Colorado. They're the ones who are pushing with the most force on the
hmm
briefs and that kind of thing. The Secretary of State of Colorado's kind of throwing their hands up, but she was sued, so they're telling her that she has to do a certain thing.
gotcha.
So that's kind of where they're at. I don't really listen. There's a lot of agency fact finding, agency applications of laws in the federal system and in the state system. Like, just to give you an example, immigration is done usually entirely in both the ICE and and the Department of Homeland Security, and then adjudicated in the Department of Justice and the Executive Office for Immigration Review. Those are determinations about people's right to stay in the United States. There are some bases under which it's appealable to federal courts. Just because something is initially done by an executive official or an officer or an administrative judge doesn't mean that there aren't channels to have that appealed. And so I
Fair.
don't think that this is a very likely doomsday scenario where we're going to see everyone disqualifying everyone without intervention from the courts.
Fair enough. We'll turn to some questions now. So the first one is, and we're gonna then go back in order. Was it a right wing org that brought the suit? You want to take that?
Oh, that's a good question.
Oh, I know that one. So Citizens for Responsibility and Ethics in Washington. They are a left wing anti corruption watchdog group. They filed the suit. They brought the suit on behalf of Republican voters in Colorado and
And unaffiliated, I think.
unaffiliated voters. So actually, no known Democrat was involved. And then we're going to go back and take actually another question from Arian as well. Let's see, because you mentioned it earlier.
Mhm.
Hope Pisco, because you mentioned general ballots versus primary ballots. Hope Pisco will cover if there's a difference between putting Trump on the ballot for primary in comparison to the general. So you want to address that?
Yeah, for sure. So it's not entirely clear to me that just because there's a qualification um, requirement that says you cannot be president if X or you will not hold office, that's equivalent to you cannot be on the ballot for X. So you could think of a court coming to the conclusion, well, Obama can't be president for the third time, but we have no authority to take him off the ballot. That could be like a position that one could reasonably hold. And so in your mind, sort of analytically, you can sort of put them in three boxes: the power to hold office, the power to be on the general election ballot, and the power to be on the primary ballot. Those are, conceptually, you could have different answers to all three of these. Um, the procedural posture of this case is we're not dealing with general election ballots yet, because obviously it's not time for the general election yet. These are all Republican primaries that we're getting ready for, and so the difference is important to the extent that the enforcement mechanism of Section 3 is directed towards either primary or general or both or none. Right? There's a certain state, Minnesota, says there is no. We recently went to the Supreme Court. There is no authority for the Secretary of State to disqualify anyone from the primary ballot, so long as that they're
Even a 28-year-old Argentinian.
Correct. Yeah.
Right.
So what they're saying there is, listen, this is just a decision. There's no authority for our courts or for our Secretary of State to disqualify someone from a primary ballot. That's a matter of state Minnesota law, and the Constitution. I mean, that's the end of it so far as state law is concerned.
So to tease this out a bit, then let's say, what state did you say that was the case in?
It was Minnesota, I believe.
Minnesota. So let's use my example, my off the hand example of a 28-year-old Argentinian, somebody just here on a visa, just visiting,
Mm-hmm.
not a resident, not a citizen, and they decide to throw their name on the ballot. So you're saying Minnesota law has no mechanism by which, or doesn't take upon itself a mechanism by which to kick them off the ballot. But then let's say for whatever reason, just some accident of fate, they win the election. What happens then?
Then it would be what Minnesota Supreme Court says is that the state official would have authority, I believe the Secretary of State, to disqualify them from the general. And so if the Republicans put up, let's say, a chair or a cat or an idea as their primary.
I just want to say real quick, all of these things would be eminently preferable to Trump anyway. Just throwing that out there. Please run a chair, Republicans. I might even vote differently. No, go ahead.
Yeah. So saying that you don't have the authority to disqualify any candidate from the primary ballot means I don't know why they wouldn't be allowed to nominate an inanimate object to be their candidate, and there would be no authority. Obviously, an inanimate object cannot be the president of the United States, or like an AI or something. Imagine that. Although we,
that'll be another live stream. Yeah, Jesus.
Yeah,
sure. Yeah.
So, in that case, right, like Minnesota could have passed a law that says the Secretary of State has authority to determine the qualifications of primary candidates, and then what the Minnesota Supreme Court says is we would have reached the merits, and we would have judged whether a candidate is qualified or not. So it's a matter of state law or whatever the enforcement mechanism is, whether it extends to primary, to general.
So that's why I was curious. So just to clarify, Minnesota says nothing about the primary, but will enforce at the general, or neither?
Yeah, but that's a problem, right? Yeah, they say will enforce at the general.
Okay.
That's what they said. And so presumably they will reach the merits in the general, assuming the Supreme Court hasn't already taken the Colorado case, whichever way it goes. One of the problems, though, is it's a bit of a dodge, because by the time Trump is a general election candidate, there's really no more time for the Republican Party to pick someone else. Imagine the partisan rancor or the Republican rage if their Republican nominee, which they spend how many millions of dollars and how much time and effort and energy were, after they're nominated in sometime in 2024, after this goes to the courts and to the Supreme Court ultimately, the Supreme Court says, hey, I know you nominated this guy for your party's nominee, but he's not eligible to be on the general election ballot. That could be highly, highly problematic. And so timing is a huge issue here. That's why the Colorado case seems like it's going to be one of the only vehicles to reasonably get to the Supreme Court before chaos sort of breaks out.
So you mentioned chaos there, and again, I'll tease this out. Just one more thing, and then we'll go on to some more questions. But when it comes to a court making its decision, be a district court, be it a state Supreme Court, being some sort of like any appellate court or the United States Supreme Court, in terms of their like jurisprudence or the prism by which they adjudicate decisions, do they not have some sort of obligation to rule in a way? I guess what I'm saying is like, doesn't that have to be a factor? Like if they say, if they're like, if as they're deciding, they're thinking, yeah, Section 3 of the 14th Amendment does disqualify Donald Trump, but then the question becomes where? Aren't they obligated in some way, shape, or form to factor in the potential public backlash or how it could disenfranchise a particular party by waiting too long to kick him off? Or no, is that not something that they do, can, or should consider?
Yeah, some of the more seasoned lawyers maybe can answer this better than I can, but I would think that's a remedy question, kind of. So, in the sense of, should a judge or court consider doing something for the overriding public interest if it's plainly contrary to what the law says? I think most people would say no, right? Like if Minnesota Supreme Court says there's no way that our laws allow for you to strike someone from a primary ballot, and interpreting it that way would be a clear violation of our laws, I don't think anyone would be arguing, but they should do it anyway. They should break the law for the overriding interest of the public. How I could see it is, okay, we're going to rule that he's not qualified to be on the ballot or something, but for whatever reason, this does not apply to this election because of overriding public interest and whatever. Like you could think of them coming to a legal conclusion and crafting the remedy so as to lessen the impact on like the general public. A way you could think of this also is, let's say, and this has actually been the case for some of the election lawsuits. There have been, I think there's at least one case out of Wisconsin that found that certain things done in the 2020 election were not allowed. They have found that. There's a small number of cases. One of them was I think there was an effort by the Secretary of State in Wisconsin to register people. And there are some rules about how you go about doing that. And one of the methods they did, involving not like a ton of registrants, was, I think they said that was against Wisconsin law. The remedy in that case is not to undo the entire election. You can imagine, you could make an argument, well, if anything's illegal, it should be undone. But, the court's not going to do that. And so there are some ways in which the public interest could affect, I think, the remedy or what the court does. But I don't think the court's going to ever admit that we're breaking the law in order to affect a good outcome for the general public.
All right, so we'll go on to some more questions. Let's see here. Tough question. Donald J. Trump is, in my mind, guilty of treason, sedition, insurrection, and espionage, among others. Isn't Biden complicit in his crimes by not jailing him by now? If so, how can we support him?
Yeah, no. So first of all, the crimes mentioned were insurrection, sedition, and espionage.
Treason, sedition, insurrection, and espionage. Yeah.
So treason has a very particular definition that would be a hard sell for even the biggest Trump detractors, which I would put myself among some of the biggest.
Yeah,
Trump
you and I are holding hands there, buddy.
So there's a very, now I will say he's a traitor in the layman person definition of what it is to be a traitor, because I think he betrays what the Constitution is about. He betrays what a president's supposed to do. But the specific legal definition of treason is it's a much more narrow thing. For espionage, he is being charged under the espionage statute, the Espionage Act, not necessarily just for espionage, but for maintaining and withholding national defense information and classified information. So he's already been charged with that. He's already been charged with things related to January 6th, so not insurrection specifically. Again, insurrection usually requires force. Now, Donald Trump may have incited insurrection, but he did not use force, unless you count like the allegation of punching his
his limousine driver. Let me ask you this real quick
Yeah.
on that note on the insurrection one. Maybe you can help there too, because it also brings us back to the Colorado case in question. Judge Wallace, who is a district court judge in Colorado, she found two things, and I want you to explain the importance of this. What first, January 6th was indeed an insurrection in her ruling. Donald Trump is an insurrectionist by engaging in it, that he is engaged in insurrection. So number one, how important are these distinctions? Like, how weighty are they? The fact that a judge put it in a ruling somewhere in the United States. And two, how distinct is it from, because insurrection is also a convictable crime, right? Okay, a prosecutable crime. So how important is this that a judge found it? And what is the difference between her finding it and also Donald Trump being prosecuted and convicted for it?
Yeah, so a lot of differences there. And don't worry, the person over just asked that question. We will get back to how it affects my vision of Biden. I know that was part of the question, but I think this is a really important digression. So a lot of differences between the crime of insurrection and insurrection as known under Section 3 of the 14th Amendment. Number one, just as a matter of using the same word, the same word can have different definitions in different contexts. And using insurrection as the U.S. Criminal Code defines it requires a show of force, as I believe I recall the statute does. And so that's not necessarily the same as what is, the historical understanding of what insurrection means for purposes of Section 3. The way someone would interpret Section 3 would involve a lot of looking at like what these words meant back in the day, the general definition, and of course there are different interpretive tools that are used to interpret a criminal statute that's a criminal statute as opposed to a general constitutional provision. So how people look at just statutes is very different than how people look at constitutional provisions, and then more specifically how people look at criminal provisions is very different than what people look at non-criminal provisions. And of course, Section 3 is not criminal. And so just as a matter of statutory interpretation, it's not necessarily coextensive, the Section 3 insurrection and the crime of insurrection. And there are some important differences why he might be eligible for one versus the other, and why he might not be charged for one, but he may be ineligible. Number one, and this kind of relates to the Biden question about why, should I support someone who doesn't support this charge? When you're making the prosecutorial decision, a lot of it, you have to go against the beyond a reasonable doubt standard of proof. That's a different standard of proof usually than like the general civil standard of proof, like preponderance of the evidence. And so the kind of and it wouldn't look good, right, for you to charge something that maybe we can convict on it, but we're not 100% sure. Failing in the criminal context might have a huge social penalty that the prosecutor is considering, and might be institutionally not in their interest to do because of the higher burdens. And so there could be a lot going into a prosecutorial decision not to charge for insurrection. In this specific context, engaging in insurrection, as the judge found it in Colorado, is much broader than the criminal statute in terms of the kinds of things that would count for engagement. We don't have a final ruling on what would count as engagement. That's one of the key issues in these cases. What does it mean to engage in insurrection? What does it mean to give aid or comfort to the enemies of the Constitution? And then you asked, like, what is the significance of a court finding that there is
sure, since he's not been prosecuted or convicted of insurrection, is it or is it not important that a sitting judge ruled that it was an insurrection and he was an insurrectionist for having engaged in it?
It's important procedurally in that this case probably has some more legs because the judge found it, but it's not controlling on anybody, right? Just like the other than the the case itself, in the world in which this was never appealed, it would obviously be controlling on the parties, but it's not controlling on other states. It's not controlling on Congress, just like Congress's acquittal in the insurrection impeachment matter is not controlling on the courts. The courts have kind of lines of authority over, so like the state court system of a given state the appellate courts will be controlling precedent over the lower courts. The determination is a trial court determination that could be convincing, that could be useful to cite for purposes of persuasion, but it's not controlling. If the Colorado Supreme Court affirms that finding, that would be controlling all of Colorado. And of course, if the Supreme Court affirms that finding, that would be controlling on the United States.
Sure. I should have clarified, because I at least understood the skeletal structure. What I mean is, do you think from a matter of the legal history of the United States that Donald Trump was found to be a former president, has been ruled to be an insurrectionist? Do you think that has significance, even if it's not a controlling interest or controlling ruling? Like if somebody says, Pisco, holy shit, a former president has been found to be, or would you say, well, it was just a district court in a state somewhere? Because I've heard people say that. I've seen comments in my videos, because of course I make a big deal about it. I think it's huge, but I'm not an attorney. Others say, okay, that's one freaking judge in Colorado. Who cares?
I'm about halfway. I mean, it's very significant because it shows that there's at least some judges in this country that are willing to apply this faithfully, at least the part about engagement in insurrection and the definition of insurrection. But if there were a judge in some state that, in Louisiana or something, or in Florida, who said this is clearly not an insurrection, I'm not going to be like, well, that ends the matter. That's
Sure.
significant, right? So once an appellate court rules in on it, then we're like, oh, okay. But I'm not going to, just like I would not feel like this is super impressive if there were some conservative state or more right-wing leaning judicial state saying that it's not an insurrection and he did not engage in it. I don't think that we should be, presumptuous or over dramatic at that ruling, knowing that it could come apart tomorrow or whenever, right? I would say by the time if the Colorado Supreme Court says, yes, it is insurrection, and yes, he did engage in it, and yes, it applies to the president, that would be hugely significant, because it would mean almost certainly the Supreme Court's going to hear it. They might hear it anyway.
Mm-hmm.
But I would be, it's significant, but it's not like, oh my God.
Sure. It's certainly not the end of the conversation. I completely agree with that. So I think you made a fair case here. Now, I do want to go to, because of course the follow-up question is, well, how likely is it that the Colorado Supreme Court overturns that finding? And of course, that leads us into today's oral argument. So we'll get to that, but I still want to have some more questions answered. Sumlin here asked a really good one I've never seen before. What about disqualifying after the fact? Like they meet all the qualifications, get elected, then take office, then commit insurrection. What about then? That is an excellent question, because technically Donald Trump was in office during January 6th for another 15 days.
That is an amazing question. And I think, in my personal opinion, it's the hardest question for petitioners to answer. That is, what do we make of the fact that, yes, if you think he engaged in insurrection, he did so while in office? Does that immediately eject him from office? What about everything he does in the interim? Trump did stuff after he engaged in insurrection. Trump, I believe, pardoned people.
Yes.
After that. Does the stuff that he did have any legal weight? Or is it an ultra virus? Ultra virus is a term meaning without authority, right? Did he do everything without authority, right? Is Vice President Pence really the 46th president of the United States, and Joe Biden is the 47th president of the United States? These are all super tricky questions about how Section 3 applies, while someone is in office, and they're not answered. And they're the hardest to deal with because, in my opinion, the constitutional answer is yes. The constitutional answer is yes. Because that's the word, right? Like, you are. I'll
bring it back up. I got it back up on the screen for you.
No person shall be, right? No person shall be an office.
Yeah.
Shall hold an office under the United States. So if you engage in insurrection, having previously taken an oath, you cannot be one of these covered offices, right? And so when does that apply? And the only intuition we have is instantly, right? It doesn't say after your term, at the very moment, but the language is definite and absolute, and it would imply instantly. But obviously, the determination that you did that isn't going to happen the moment you do it.
No,
Um,
and I'm also thinking too, like you and I, when we had that debate with Lauren De Laguna or whoever
yes.
about when we referenced, because it was either in Arizona or Colorado as well, where the 14th Amendment was used to expel that county commissioner who did participate in the January 6th insurrection. He was ejected from office by order of a judge. And then I get thinking to myself, can a district court judge kick the president of the United States out of office?
They're uncomfortable questions for petitioners. I think the ultimate answer is this applies instantly.
Sure.
And that's just what it is. And what the kind of things that you talked about in the public interest about and what I mentioned about the remedy, that could be a way where courts could say, okay, you're out of office, but the way we're crafting our remedy, it's not going to undo all the things that you did at this point in time. You could maybe think of a ruling like that, but the courts have been very loath to have direct confrontations with the executive branch. They'll order executive officials to do things, right? Stop enforcing this, stop doing that. But very seldom, if ever, have you seen the Supreme Court or a federal court directly order the president to take something, to take certain action, or to not undergo certain action. They're usually phrased towards lower officials. And the reason is, some people say, and you can have different arguments for it, is they do not want a confrontation directly with the executive branch because they don't want their rulings to not be heard and not be listened to.
Sure. Yeah, because
president.
the president always has the option of non-acquiescence, which is just you and what army,
Yeah.
Yeah.
Imagine you had a Supreme Court order that said, Donald Trump is hereby declared not a president, or the office
Is effective immediately. Yes, effective
the office of
immediately
president
vacated.
is vacant. Vice President Pence is now the president of the United States. What happens, right? That is something that the Supreme Court, I can guarantee you, would almost certainly want to avoid. But I think the correct answer, the constitutionally best answer, is the moment that you engage in insurrection, you are not an officer. You are not under those offices, having previously taken an oath, which of course you have to hold these offices. Well, arguably, and so yeah, that's the answer. That's my answer to that. But the practical answer is almost certainly a court would have to go through it and they'd craft a remedy to try to prevent the parade of horribles. But it's a very tricky issue.
So here's another one, and I know I think the paper by Stokes Paulson and Bowd get into this, but how far should insurrection get to qualify for disqualification? Where is the insurrection line? And we don't, I mean, if you want me to cite anything from the paper, I'm happy to do it since I've got it up, but I know they address it at length, but do you want to give your assessment of this?
So the answer is everyone has a line somewhere, right? And some of the difficult questions in today's oral argument involve, like, what if you're secretly planning to hurt a judge with one or more persons? You're doing it because out of political reasons, because you think that they're too liberal of a judge or too conservative of a judge, and you're planning to hurt this federal Article 3 judge. Would that be an insurrection? And so and those are difficult questions on, like, the low end of insurrection. Like, let's say that you are gathering people together to try to storm some post office or to storm some other federal function, like, I don't know, to prevent the flow of mail in the United States. My answer to that question is to look at historical examples of what the founders and framers would consider to be insurrections, things like Shays Rebellion and the Whiskey Rebellion, things like that, where it's not about overthrowing necessarily the government. That's not the line I'd draw. But it's about, like, this is going to be a weasel word, but trying to significantly undermine the enforcement of United States law, or to stop the enforcement of that law. And so I would like imagine that people gathered together and were bombing postal roads to stop the flow of mail for political reasons or something like that. I would consider that an insurrection. Let's say you were trying to storm the White House to try to, coerce the president into taking some action. I would call that an insurrection. And so everyone's going to have a line. Like, I'm not going to say that just one person's plan to steal a bunch of mail is going to qualify. But it's something that people struggle with. And it's true of a lot of things, a lot of constitutional principles, This is not the first one where people have to draw lines, right? Another one is speech, right? What is speech versus conduct? If you burn a draft card, is that speech? What if you burn the flag? Is that speech? What if you just burn anything? So there's always these kind of hard. These are just concepts and categories that are man-made, and they don't reflect some kind of underlying true objectivity. And so people have to put in reasonable lines, and that's true of tons of constitutional principles. And so in terms of guidance, I could give you reasonable, or I could give you significant. But other than that, it's just going to be using examples to try to narrow what could and couldn't be an insurrection.
I had notes somewhere on this because I've annotated this damn article to hell and back, this law review article by Bowd and Stokes Paulson, and I know they talk about this at length, but I didn't see it in the table of context. So I was gonna try to like have it up on screen while you were answering, if need be. But we'll just move on. Oh, well, I will say, obviously conservatives with whom we've debated in the past say, okay, Pisco, if January 6th was an insurrection, what about the protest at Donald Trump's inauguration? What about the protest at the Kavanaugh hearings, Justice Kavanaugh's hearings? What about during the George Floyd protests in Washington, D.C., when people threw rocks or went to the gates of the White House and Donald Trump had to be taken to a bunker? What if? Now, obviously, I think you just said, I'm sure there would be people out there who would, even potentially in good faith, make an argument that these were all insurrections. Do you think if you were to, and I don't want to spend 40 minutes on it, but would you, if you were to compare these to January 6th, why is one so clearly an insurrection to you, but the others may not be, if they may not be?
I think a lot of those are insurrections. So I'll give you some examples. So the Black Lives Matter riots related to where they're like trying to burn down or attack federal courts. I think there was at least one or two of those instances where you have, for presumably ideological reasons, that is Black empowerment and racial solidarity, or fights against discrimination, and you could agree or disagree with the underlying political message. That's an important part, where whether it's an insurrection cannot depend on whether we agree with the underlying message. If that's where we're at, then it truly is dealer's choice, and it's not connected.
So you're saying that the righteousness of a particular cause should have no bearing.
There are people who believe the Civil War was righteous and justified.
Sure.
There are people who believe 9/11 was justified, or people who think October 7th, all that stuff, right? There are tons of people who have different opinions on the rightness or wrongness of the use of violence or trying to confront or oppose the enforcement of federal law, for sure. But you cannot have that to be a basis to distinguish. I agree with on that print. You can't be like, it's okay if Democrats do it, it's not okay if Republicans do it. That's kind of like the central thesis of what I'm trying to say. So whenever they're using force as a group to try to like attack a federal installation in Black Lives Matter, absolutely, I would call that insurrection. Now, keep in mind, this only applies to previous oath takers, and so it's limited to how it's going to apply to anybody. But like, let's say that Joe Biden, as previous oath taker as vice president, went and attacked a federal court or urged other people to attack a federal court in the Black Lives Matter protest. Of course, I'd say he would be disqualified. Another one example you brought up was the
Kavanaugh riots.
Let's go there. Yeah. So the White House one first. So in the White House one, more tricky there is going to be proving intent, right? One of the reasons why the January 6th case is so clear is because we know the intention of the people in January 6th and what they were trying to do. They were trying to stop the steal. Anyone who doubts that doesn't live in reality. That's what they were trying to do. Not necessarily all of them, but the ones who entered the restricted areas, I would say the vast, vast majority of them. That was the purpose. In the case of the violence against people near the White House, if you could prove with a preponderance of evidence that the intent of the previous oath taker was to take some action to prevent Trump from executing the law, or to take some action to hurt Trump or something like that, 100% that would be an insurrection. Or even if your purpose was just to destroy the White House for purposes related to your political beliefs, I would absolutely call that an insurrection. you have to be able to prove intent with a preponderance of evidence, and it would only be applied to previous oath takers. But imagine if like Jamal Bowman or Nancy Pelosi were leading a riot against the White House because they're oath takers. Everyone would agree that these people need to be disqualified 100%. And that the Section 3 would work to do that. The Kavanaugh, go ahead.
No, well, I was going to say, if you want to comment on the Kavanaugh thing,
Yeah,
go ahead.
The Kavanaugh situation, again, I think the use of force is critical here. And just like in the insurrection, there's a degree of significance that people are going to reasonably disagree on. I don't think that anyone would think, even in the in the 19th century when the 14th Amendment was passed, that people standing up and saying something out loud, someplace where they're authorized to be, and breaking the rules of those chambers, to the extent that you're talking about people in the actual committee hearing, that would be considered a use of force significant enough for insurrection.
Fair enough.
People who are cornering Senator Flake, right? Jeff Flake.
Yeah.
Again, use of force. No, they're authorized to be there. There appears to be no use of force or threat of force. But if people were going there to like hurt Jeff Flake, of course, if there was a group of people committed and threatening him with true threats or using actual force, of course. And I think that's just obvious.
Somebody said raise his volume, so I raised your volume.
Okay, cool.
So I remember actual Justice Warrior when one of these lawsuits was filed. I'm going to pick on him for a minute.
Mm-hmm.
He said, I wish I should have thought of to bring the tweet up, but I don't have it in front of me. He said that Donald Trump could not have engaged in insurrection against the government because he would be engaging in insurrection against himself. Now, I want you to address that before, but I'll tell you how, because I responded. I was like, that assumes that the president is the government rather than the head of government.
Right.
And these things are distinct. Now, in the United Kingdom, the sovereign, even now in 2023, King Charles, even though he in practice has very little power, as far as the Constitution of the United Kingdom is concerned, the sovereign is the government. That's why the prime minister is the sovereign's prime minister. In theory, they derive all power from the crown. So the king is the government, right? It's like Palpatine, I am the Senate, it's that sort of thing. That's not the case here in the United States. The president, my understanding is, yes, constitutionally, the single most powerful office by far, but is not the government, merely the head of it. Did I get that right as far as like refuting that argument, or is there more to say there?
I would say that's a kind of formalistic argument about what it means to be. And remember, this is insurrection against the Constitution of the United States. That's the noun here, or the subject is anyone who engages in insurrection against the same. That is the Constitution of the United States. So that's very clearly, the president is not the Constitution of the United States, and so that's a semantic difference that matters. And obviously, the fact that we're not a monarchy, where the state is the head of state, that is the person of the king, is the state of England. That's never been the case in the United States of America. Even though the presidency was modeled a lot on the English notions of king, there were some very key separations, and so the president is not a king, and the government in the state is not vested in his person. And so I would agree with what you just said in terms of the kind of formal structure, and additional textual support for that is the fact that Section 3 specifies support for insurrection against the Constitution of the United States, which everyone understands in the United States. The president isn't the only one who interprets the Constitution. The courts, the judges of the United States, and even Congress interpret the Constitution of the United States. And so it's not just the president who gets a say in what the Constitution means. The Supreme Court usually says what the law is, typically, in terms of the final say, right? And so, no, I don't agree with that on a formalistic sense. I also don't agree with it in a practical sense. If it were true that the president's position on everything is the state's position, or is what the state is, then it would literally be impossible for the president to abuse his power. And the reason why that sounds familiar is because it's the same exact argument that people did in the first impeachment of Trump, when he made the quote perfect call to Zelensky, which is what they said is, what you can't just say that it was against American state policy or American State Department policy for Trump to do this, because Trump defines what state policy is. Trump defines what it is. He's the chief negotiator. He's the chief person who puts out America's position. To an extent, there's some truth in that. And to an extent, there's some truth in, we would pay a lot of deference to Abraham Lincoln's sort of his identification of an insurrection in the context of the Civil War. Or if the president came out and said and declared an insurrection that was existing, let's say, in the southern and western states or something like that, we would pay a lot of deference to that. But it's not limitless, of course, right?
Unless you believe in unitary executive theory,
right? But even then, it belies what their actual opinion would be if certain things would happen. Let me give you an example. Let's say that Joe Biden ordered Merrick Garland to arrest immediately Donald Trump, and he said, hold him for whatever reason, or like go kill him, right? No one would think that wasn't an abuse of his office worthy of impeachment. And all the Republicans would be saying, impeach him right away. They wouldn't be saying this thing like, well, whatever Trump does or whatever Biden does is, that's just what America's position is. And so there's no such thing as improper purpose, because any purpose that the president identifies is by definition a proper purpose. And so there have to be limits here.
No, I think that's a good litmus test for people to have. And this is in my argument with people who either on Twitter or elsewhere have espoused like some sort of belief in a strong unitary executive. It's like, okay, to test how sincere you are in that belief, just imagine a Democrat is wielding the kind of power that you're talking about. And then that usually triggers some sort of reconsideration.
Yeah.
So we'll go on to some other questions or some other comments. So Jeffrey Jones says, if I'm reading the 14th Amendment correctly, if we had a super majority of Republicans, they would remove the disability gladly of the 14th Amendment. I'd say, yeah, they probably would if they had the numbers.
Super majorities of both houses. Which
is
very difficult to get. And yeah, they would remove the disability, but that's what they have to do. And so the practicality of them, for me, is almost a secondary concern when it comes to applying the law for purposes of disability. It doesn't matter. You have to enforce the law whether or not it's futile, or that's the purpose of the law, whether or not it's practically futile. That's kind of my position on that. One thing I did promise the person who posted the question before
about Biden
to get back to that. The question said, I can't support Biden because number one, as a practical matter, Biden can't really, he's not supposed to influence the DOJ for reasons I just talked about. We want a separation so there's no politically motivated prosecutions. And so I would not blame Biden for the lack of prosecution in DOJ, because I wouldn't want him to have a role in the Department of Justice's prosecutions. And I think he should be impeached and removed from office if he were to meddle with Merrick Garland. What his role is to nominate the person to enforce the law. That's what he's supposed to do. And so I would have a problem with anybody blaming him for that.
I'm sorry. We have to do another important digression there, because this is something that you and I've talked about on Steven's stream and elsewhere. This is one that I know. I think it confuses actually a lot of like people who are also politics geeks. How do you square the circle, Pisco, as a matter of constitutionality? The Attorney General does work for the president. He is not equal to the president. He's not above the president. The president is his boss.
Yes.
But we also say that there are like the minutia of like individual prosecutions should be outside of what is proper for the president to influence. How do you, because somebody would come back, and actually Republicans right now are making this argument. They're saying, Ron DeSantis, for example, I know has said this in he's like, we need to get rid of the canard that the Justice Department is a quasi-independent branch. The Attorney General reports to the president is his boss, and therefore it is appropriate, if the president so chooses, to direct individual prosecutions or to forbid individual prosecutions. How do you square that circle? How can I be your boss if I can't tell you what to do?
Yeah, so it is a weird situation. Undoubtedly, what is a core executive branch function is the prosecution of people and individuals for violations of the law. That is a core key executive, as what it is to be executive. If there's any power that defines what it is to be executive, it is seizing persons and putting their ass in jail and keeping them there, or applying some other sanction to them in terms of the criminal or civil law. And the president is the head of the executive branch. The Constitution vests executive power into the president. So how can I say that it's improper for the president to enforce the law and even take direct control into of certain prosecutorial actions? I do not say that it's contrary to the power of the president to direct particular investigations. I think that it is well within his power. He absolutely, if anyone has the power to direct individual prosecutions, surely the president has more power, more authority than the attorney general. I do not say that it's against their power. What I do say is it is horrible policy, and that the president is wading in a minefield, because if the president were to use that power for an impermissible end, that is, abuse the power for political purposes or whatever, they should be validly subject to impeachment. And so these are norms, I believe, good norms, to safeguard the president from abuse of power and to give him the authority to direct in general the execution of the law, but to remove the specter of abuse of power. And so, again, I think it's really good policy that should be enforced with the impeachment power, but I don't disagree that the president has the authority to, if he wanted to, direct individual prosecutions. I just think that he should be.
So it's not that you're saying he'd be acting extrajudiciously or extra legally, rather.
Right.
It's just that it would be ethically problematic, if not just outright corrupt. Don't even go down the road. Allow the attorney general to be the one to shape, which honestly, I mean, my understanding is it's not even really the attorney general. A lot of most prosecution decisions, I imagine, don't even make their way to the attorney general's desk. It's probably the deputy AG or it's an executive branch self-restraint that is extremely important, should be guarded, because it prevents abuse of power. Just like, let me give you another example. Let's say the president has, no one denies, the president has absolute, some might say, unilateral authority with respect to pardons, right? But if a president were to pardon everyone who did it, for whom a crime was done on his behalf, right? Who, let's say that the president was directing people to do crimes just for him and then pardoning them, or the president pardoned or himself,
himself, or every single federal criminal or whatever. If the president were to do that, notwithstanding the fact that it's within his power, I think that, of course, we'd be thinking about impeaching him. The notion of an abuse of power, in order for it to be an abuse of power, in my opinion, someone has to have the power, right? You can't abuse a power you don't have.
Sure.
And so that's why that safeguard's in place, and why it should be guarded jealously, and why Congress should enforce that safeguard. And I really do think if Joe Biden were directing the Department of Justice to go after particular individuals, absent some incredibly rare or exigent circumstance, and in such circumstances, I would expect the DOJ to be acting by itself anyway.
Right.
Absent those circumstances, like let's say that there's some, I don't know, some Department of Justice branch is not acting and arresting some terrorist or some horrible public safety thing. Maybe I'll make some limited exception for that. But absent that, I would say Biden should be removed and impeached and then removed.
Fair. Let's see here. I got some other things. So somebody asked about why the judge. Oh, come on. Where did I do it? What did I do?
While you're looking, just real quick.
Yeah, go ahead. You
I'm sorry, fully finishing.
No, you're fine.
That guy, whoever said that.
Yeah, go ahead.
So I do think that Biden should stay out of the Department of Justice, and so I don't think that you should not vote for him because the DOJ is not as aggressive as you want, because I don't think you should be directing the DOJ specifically. And also, I think that the DOJ is going after Trump on things they should, and on really, in my opinion, very strong cases. And so I don't really see the reason for you to be disappointed in the DOJ. I think they're doing a fantastic job with respect to the Trump indictments.
One thing I will say, I found the question that I wanted to pull up here. One thing I will say when it comes to President Biden's DOJ, and honestly, Pisco, you may disagree or you may agree just somewhat less forcibly than I do. So that Washington Post did this really good expose probably 6 months ago, where, I mean, it was huge. It was all over the news and they cited a gazillion sources. They have credible evidence from DOJ sources, FBI sources, that Merrick Garland's DOJ slow walked investigating Donald Trump for the first year of Biden's presidency. Now, I say this as somebody who's not an attorney, but political actor. That's infuriating, because the idea is, you go. What does Merrick Garland always say? We will follow the law without fear or favor. But you could make the argument they showed both if you slow walk an investigation. So before we go to that question, let me ask you, in your opinion, because we're buried in platitudes all the time. No one's above the law, Pisco. Donald Trump is not above the law. But you can make the argument, be it with how he's been treated with gag orders or the enforcement of gag orders, or the DOJ and NARA with the classified documents, or the slowness with which Merrick Garland's DOJ prosecuted Trump, that he has been treated with kid gloves. Maybe not now that the ball's rolling, but in terms of their hesitance, I think you could easily make that argument. Do you agree that that argument can be made? Do you think that it was appropriate for them to engage in that hesitance? And if you do, are we not tacitly conceding that Donald Trump or certain high-level politicians are indeed above the law?
Yeah, I mean, if to the extent that there was slow walking, and I don't know because I haven't looked.
I'll link you to that later. Yeah,
much, but that's totally unjustified. He should have been investigated. Full investigation should have been opened into Donald Trump the minute January 6th happened, and maybe even before that. When he was asking the DOJ to do certain things, when he was organizing as soon as they got word or information about the fake elector scheme. Now, as just a matter of continuity and as a matter of the linearity of time, the DOJ might not have been sort of aware of certain allegations until later in time. And also remember, it's Bill Barr who's not Bill Barr. At least for some of the relevant period, it is Bill Barr. But after December, I believe he resigns or is fired. And so is it Rosen, acting attorney general?
That was, I think, before Barr. Wasn't Rosen the one between it was during the Mueller report. Rosen, I think, was the one who appointed Bob Mueller. So I can't remember who was the acting.
Rosenberg.
Rosenberg. Oh, okay.
Wait.
Rosenstein. Rod Rosenstein. Yeah. So I don't know who was the acting AG. I can't remember who's the acting AG. Damn, he went through so many people. I can't remember. And I do this.
I think it might be Jeff Rosen,
yeah.
but
go ahead. Yeah.
Yeah. So, but anyway, there are reasons why there could be delays, natural delays that make sense in the initial period in terms of gathering the evidence and all that stuff. But after January 6th, I think there was plenty of reason to investigate the president for what occurred on that day. And so, to the extent there was slow walking of that by Merrick Garland and the others, it's contemptible. It's one of the worst moments, I believe, in American history. Certainly in the 21st century, one of the worst moments for our country. And so it absolutely should have been investigated to the very top. If it wasn't, I would think that's really bad.
So this brings us to, this is the one question I wanted to point out. So how did the judge, Sarah Wallace, exclude the president in her ruling if Trump was able to be on the ballot? So this is obviously the thing that's being appealed in today's oral arguments. It gets us closer to that particular topic. So Pisco, if she found that January 6th was an insurrection and that Trump was an insurrectionist, why didn't she disqualify him under the remit of the Section 3 of the 14th Amendment?
Yeah, it's because so the first 90 or so pages of the opinion of the trial court, this lower court, this judge was talking about all the reasons why Trump engaged in insurrection, that this was an insurrection, that the First Amendment didn't protect or doesn't protect what Trump did, and sort of was setting up potentially, unless you could read between the lines and some of the little phrases that she was using, that Trump would be disqualified. The reason why Trump wasn't disqualified in her ruling was because she said that categorically Section 3 does not apply to people wishing to become the president, and it does not apply to individuals who swore an oath as president and only president. And so that argument goes back to the text of the Section 3 of the 14th Amendment, which says that you shall not be someone under in an office, will not hold office under the United States. And so what the judge said is the office of president is not under the United States, or is not an office under the United States. and that if you've given an oath to support the Constitution of the United States, it doesn't include president, because the president is not an officer of the United States and never swore an oath to support the Constitution of the United States.
The president only took an oath to defend, protect, and preserve the Constitution, not support it.
So it's a categorical argument that essentially this don't apply to presidents in two ways, right? Either as a
the matter of the wording of the oath, that's
right.
one.
I guess three then. Well, three kind of relates to two.
Yeah.
Either you can't be, you could be anything. You could be dog catcher. You could be sheriff. You can't be dog catcher. You can't be sheriff. You can't be senator. You can't be representative, but you can be president. That's one way, right? Like, let's say that you are Jefferson Davis, who was, of course, the president of the Confederacy. Jefferson Davis could not be Senator Davis, but Jefferson Davis could be President Davis of the United States after the Civil War. That's one of the branches of it. And the second branch of it, which is informed by the oath part of it, is if Abraham Lincoln, let's say Abraham Lincoln never took another oath and only took the oath for president. If Abraham Lincoln defected to the Confederacy, he would also be eligible for anything. Including
a third term as president.
As president, right?
Yeah.
So that all of that means that the president as an office is not one of the offices that's incapacitated by Section 3, and that if you've only sworn an oath as president, that is not a qualifying oath for application of Section 3. It's bizarre, and I hate it, and I don't think that it should not be good law. But there are reasons why people agree with it. Some people.
So let's see. We'll address some more down here. Flo Trace said hi, by the way. He was in here and he found the tweet to which we were referring.
Who's Flo Trace?
Flo. I was like, oh shit, he's gonna let's see. Lots of good conversations and debate here. Wish we had time to go through all of them, but we don't. Okay, here's one. If Trump gets indicted on the Washington insurrection trial, can he stay on the ballot during his appeal?
Yeah, so that indictment is not connected to the Section 3 stuff. So he first of all hasn't been charged with insurrection or incitement to insurrection in the Washington case, and so as a matter of just like what the thing is,
it was all conspiracy, wasn't it?
Yeah, conspiracy and obstruction.
Mm-hmm.
Of an official proceeding, conspiracy to obstruct official proceeding, conspiracy for, there's a civil rights one related to voting, and there's one more other conspiracy, but it's not insurrection, the criminal statute. So there's no connection between that and the Section 3.
So Jay Culp says her ruling is nonsense. How can you not support the U.S. if you're defending it?
Those were some of the questions in the oral arguments. Where Trump's lawyer said he gave reasons why, because some of the judges or justices had argued or had said, just as that the presidential oath is superior, is the strongest oath, and he said I wouldn't concede that, and he said there are reasons. He said the oath of support is more broad, and therefore it could be argued that it's stronger than the president's oath, and therefore they're different oaths. Whereas the president does not swear an oath of support only to defend. Preserve, protect, and defend. And so I don't agree with that. I think that the president takes an oath of support of the United States and also takes his higher oath. And so he takes both. But not everyone agrees.
So, and that brings us to the issue at appeal. So I don't want to go through the whole thing. Again, these are notes that I made of Cruz's appeal, which I thought was just impeccably written. Some highlights I want to point out, and Pisco, at any time you interrupt if there's any extra analysis or points you want to say. So this is the appeal, folks. We did this in a video. This is a copy of the appeal after the Colorado judge made her ruling that January 6th was an insurrection. Trump is an insurrectionist, but Trump is not disqualified under Section 3. This is right here what they're trying to make the case for in today's oral arguments. So the court found that the violent attack on the U.S. Capitol was an insurrection against the Constitution. And the court found that the former president engaged in that insurrection. But the court held that Section 3's disqualification rule does not apply to insurrectionist former presidents, nor to any insurrectionist running for president. In effect, that this office alone is above the law. Stop right there to ask that characterization, in effect, that that office is above the law. I, of course, would phrase it that way. Do you think that that's implicit, whether the judge intended to or not? But do you think that that is implied by her ruling?
No. Can you go back up to the wording?
Sure.
So, no, because I don't think the office is above the law in the sense of absolutely above the law. But what she's saying, her argument, if you take it and you accept it, is that it's not included in this particular constitutional provision.
Well, I suppose.
Go ahead.
I'm sorry. Go ahead. No, go ahead, please.
I think that it is true that it's ridiculous to say that either the U.S. presidency is not an office under the United States or that the president is not an officer of the United States. I think that is blatantly ridiculous looking at the text of the Constitution, how everyone understands those words and what they mean to normal people, and the mess that would be created if you interpret it otherwise. But I don't think it goes so far as to say generally it means that the office is above the law, because there are other provisions to rein in the president. But I understand why they, as a atmospheric, why it sounds good.
Fair. Would you say that her ruling implies that the presidency is beyond insurrection, that insurrection and holding the presidency are mutually exclusive as a matter of constitutional law?
Yes. I mean,
Okay.
that is true as purposes for Section 3, yes. And if you take the Trump line on the immunity of the president with respect to criminal law, which he's argued for in the DC cases, that he's absolutely immune
Oh, God, yeah.
during and after his presidency and term of office for anything done while in office that even reaches the outer perimeters of his powers, then if you accepted that, and if the courts would accept that, then yes, he would be beyond any kind of breach of insurrection laws.
I'll also say, do you find it, again, I say this as somebody who's not an attorney. I know we use the word ridiculous and preposterous, and I know, like, when people talk about Trump and the presidency and his abuses of power, they just say the phrase, he was the president of the United States. We load so much in that phrase. But the way I keep looking at this ruling is it requires the assumption that the framers of the amendment intended to protect the country from insurrectionist office holders, except when it comes to the most powerful and important office, which isn't just ridiculous. It's almost counterintuitive, isn't it? I mean, like, it's almost like saying, I can't trust you with this knife. You're too dangerous with this knife.
So
but I'm going to give you but I'm going to give you a bazooka. Am I thinking about this wrong?
I do think you're thinking about it right. And one of the best moments of the oral arguments, I had to pause at a certain because I had some meetings, but one of the best moments of the oral arguments is when the Supreme Court of Colorado is essentially asking the Trump attorney, hey, I understand you have this like kind of linguistic language argument, text argument for why this isn't applicable to the president, but can you give me a rationale for why? And he was just silent, and he just like stammered for a bit, and it was like this very pregnant pause, because there is no good rationale. I mean, maybe you could take the line that, well, the president defines what an insurrection is because he's the president, and that's the kind of thing we talked about before, where the what's his name? The actual Justice Court,
AJW,
argument that the president by definition cannot be an insurrection. So that's the one argument as a rationale, but there's no evidence of that actually being the purpose, and it's a hard thing to bring up in the courts, and so I didn't hear him bring it up. But I don't think there is a good rationale for why should you be disqualified to be senator but not president? Why should you be immune? If you take an oath as a military officer or as a lowly, lower inferior office, you're going to be unable to hold office, but not as the highest oath in the land. I think that's ridiculous, and there's no good rationale.
Yeah, and the section I just had up there went to that effect at the part of so again, certain things that really jumped out at me before you get to the oral arguments in this appeal, that not only did the district court rule in favor of petitioners on every factual issue necessary to disqualify Trump from the ballot, but it also found for petitioners on every legal issue necessary to grant the petition, save for one. And again, not to spend too much time on it, is it uncommon? Because again, I read this and I'm thinking, wow, that seems so unusual that the judge basically goes 98% of the way and then veers off in the final 2%, which was what seemed to be the case in her ruling. She spent the vast majority laying out the rationale for finding that the January 6th insurrection was indeed that and that Trump engaged in it. Did you find it unusual reading her opinion that she went so far gesturing in that direction only to veer off at the last second?
Did I find it surprising?
Yeah.
Not necessarily, because I think that courts are looking for a way to dodge. If I'm just being a realist,
Sure.
I think that courts are looking for a way to dodge being the ones who disqualify Trump. And it must not feel nice knowing if you like are about to make a ruling, if I'm being a realist, to know that like if you were to do that, you'd be subject to all sorts of harassment and all sorts of attacks.
Maybe more. Yeah.
And maybe more. So it's just really, it's not surprising. It wouldn't be surprising to me that a judge would procedurally try to dodge it or to invoke. There are a couple of doctrines, procedural doctrines that some courts have been using to try to skirt the issue. One is the political question doctrine, which essentially says that courts are not competent to hear these kinds of claims, which I think is blatantly ridiculous. Another kind of one is standing doctrine, which I think is a more applicable one. I don't want anyone to just be able to sue in the federal courts necessarily for it. But
Sure.
there are ways that you can jump around some of these questions. Another one is ripeness. Like, do we know Trump's going to be on the general ballot? No, not yet, I guess. And so there's some questions about whether this is a ripe issue.
Damn, but even if that's the parameter, that gives you a narrow time frame to address it, right?
Yeah.
So other things that
there are exceptions, right? There are exceptions to some of these doctrines that courts will generally use for things like this, where it's really like a short time window. But it would be very simple or easy for a court to use one of these procedural issues to just dodge the underlying merits question. And this is the first court to reach the merits, the lower court at least. And it's not clear that the Supreme Court is gonna be okay with the court below reaching the merits. And so we don't actually know. Both parties appealed. The petitioners appealed with respect to the officer question, and Trump appealed with respect to everything else. And
right,
so
he didn't like being found that he was an insurrectionist. Yeah. So, other interesting things in the appeal was that the petitioner's expert, Gerard Magliocha, is apparently like if not one of the foremost experts on Section 3 of the 14th Amendment. Apparently, like even sections of constitutional amendments are so important and are so analyzed that you can be an excerpt in a single paragraph.
That's why I started this entire thing by saying, just being a lawyer, and let me be real with you guys, there are a lot of dumb lawyers, and I'm not saying that I'm a smart lawyer, or that really you should trust any lawyer on any given topic. There's so many specifications, so many concentrations and stuff that it's not enough just to be a lawyer. And especially, I recently had a talk with Destiny about some international law stuff, and I was very careful at the start of that to be like, I don't know anything about international law, and it shows because I really don't. So just know that there are people who are highly specialized in not just constitutional law, but this specific provision, who know more.
Well, with that in mind, so the appeal makes the case that, listen, and again, obviously this is one-sided. This is the petitioners making the appeal, so they may have misrepresented this, but I don't think so. They're basically saying that when it comes to expert witnesses, Trump was outmatched. That the team trying to get him disqualified under the Section 3 of the 14th Amendment has the foremost Section 3 expert alive. And Trump had a retired constitutional law professor who, if you read the appeal, either took no position on various issues or conceded, like, for example, that he too would be inclined to think that the presidency is an office under the United States, given the Constitution repeatedly refers to the office of the presidency, that he even conceded that the preponderance of evidence agrees with the idea that Section 3 of the 14th Amendment would apply. Like that basically, go ahead, please interrupt. Yeah.
No, it's just because the reason why is if you scrutinize it a lot, this officer question, everything kind of falls apart, because the whole idea of quote originalism or textualism is you're supposed to take a look at the text and what do people think these words mean, and just the notion that the framers of the Constitution would devise this secret code to parse out the difference between under and of, and to have it have some humongous significance, and to do this little oath thing without being super specific about it. It flies in the face of a lot of, I think, interpretive doctrines of the courts. And I just think it sounds ridiculous from a rationale perspective. There was invocations of the absurdity doctrine, which is only supposed to be invoked when there is just like no reasonable interpretation that.
Well, can you clarify on that? Because this is something that's mentioned in the appeal, something to the effect of that you talk about like interpretive doctrines or interpretive prisms. There's a line in here, and I might be able to control F and find it. Apparently, and I think they even quote Heller. They quote Justice Scalia in Heller, where Scalia takes the position that when it comes to interpreting the Constitution, the general principle is you're supposed to do it in the most straightforward, non-technical way as possible, because the Constitution was written not for legal scholars, but for American citizens. And I'm paraphrasing here immensely, but the idea is you're not supposed to torture yourself into obscure, absurd, highly technical interpretations. Do you want to comment on that?
I think that is absolutely would be Scalia's approach. I mean, you're talking about a guy whose version of originalism is called original public meaning. Original public meaning. What did the public understand these words to mean at the time of their writing? This is someone who discounted, usually, legislative history. He says that, almost always, right, to discount the use of, when I say legislative history, I mean, there's been citations to like debates of people who are ratifying it, citations to like drafts and stuff.
Attorneys general opinions from concurrent attorneys general.
Practice, common practice at the time, of the time, to the extent that it's not informing the text, the actual written text of what it meant. So he'll say something like, no one thought that when they ratified the 14th Amendment, that what those words meant was banning regulations against gay marriage, right? So he would very much take, what do these words literally mean to the people at the time? What does the original public mean? That doesn't mean that he wouldn't respect technical language or technical distinctions at all, or that he wouldn't think of the drafters as incorporating other sources for purposes of informing what they meant, but just that he put a lot of emphasis on the meaning of these words as understood at the time to the public. And so I think that it's bizarre, without more textual support or a lot more legislative history, to say that this is very clearly meant to impart some dichotomy between the various offices, as opposed to just a general catch-all that includes everybody.
So to that point, the appeal says we know the presidency is an office under the United States because the Constitution repeatedly says so. The Constitution refers to the presidency as an office 25 times. Section 3 thus applies to the presidency. It prohibits disqualified individuals from holding any office, civil or military, under the United States, using deliberately broad language that permits no exceptions. And again, at any point, if you want to interrupt with your own analysis, I'm just recapping this so then you can recap.
A lot of those references are thought about, and it's kind of because there will be times where it'll say the president shall appoint all officers, right?
Thank you. Okay, that's a great one. So that's the conflict, or the alleged conflict, with the appointments clause.
Yeah.
Do you based on the oral arguments, do you have any opinions on that? Because my understanding is just the idea that one officer appoints another officer doesn't preclude the first officer from being an officer, right? Yeah.
Other times they'll say all other officers, the president, vice president, and other officers. That is, and there's a good rationale. So there's a lot of uses of that where president is using the same line as officer, but of course it doesn't sort of undo the fact that the president can also be an officer.
They're not mutually exclusive.
Right, correct. And the president is appointed via the Electoral College. That's how they're appointed. And so it wouldn't make sense to need to,
the president can't appoint himself.
They already specify how the president's appointed. And then this other place where it says president, vice president, and all other civil officers.
Other civil officers, implying the president and vice president are themselves officers.
And there's a good rationale for why they would call out the president, vice president, is one, for absolute clarity, because the president is also a military officer by virtue of being commander in chief, and the vice president is the president of the Senate,
presiding officer of the Senate.
Right.
And it's something else too. They cite in the appeal. I don't know if they do in the oral arguments, and you can tell me. We can even just start talking about it now.
Mhm.
They cite, understanding of what the word office and officer meant at the time. They cite dictionaries from before the ratification, contemporaneous with the ratification, and afterwards. They refer to the fact that sitting presidents referred to themselves and other presidents
Yes,
as officers,
they always
office
have.
holders, chief executives. They refer to concurrent opinions or contemporaneous position. Like, for example, I know at one point in the appeal, they mentioned that when it came to Section 3 of the 14th Amendment, when there was a judge, obviously not deciding over the president, but another person who may or may not have been disqualified under Section 3 of the 14th Amendment, there is a part in their ruling where they say essentially that the Section 3 of the 14th Amendment does not require strict, like when it says support the Constitution. I'll try to find it here in the appeal, but basically the judge is saying, we're not obligated to be to use those exact words, but just the broader understanding of what to support the Constitution means. So it seems like when it comes to firepower, legal firepower, historical precedents and understanding, and maybe this manifested itself differently in the oral arguments, but damn, it seems like the petitioners have infinitely more on their side. Is that a fair characterization? Is this an uneven fight, do you think, in terms
but
of
I'm
support?
biased because I've always thought that they've had the
Sure.
better of the arguments there. And
But I feel like but hang on, I feel like if it manifested itself differently in oral arguments, you wouldn't be happy about it, but you'd be like, damn, they put up a better argument than
with the
what I
caveat
thought.
that I didn't watch the rebuttal, and I only
Sure.
watched like I think 3/4 of the Trump lawyers.
Fair.
I was reasonably happy with how the questioning went for in terms of who had the better of the arguments. I was started off as a skeptic, as you recall. The person who first started bringing this in my ear was you when you tweeted at me. I think some months ago, and I was like, I don't really think this is a good argument because I was just like thinking about it and I didn't really know anything about it. And then after reading that paper, I was like, oh, like these are originalist conservatives and I feel like the arguments are on their side. And then the more I think about it, the more I do investigations, I think the stronger they become. There are a lot of really, really tough questions that have no answers for the respondents in this case, or the I don't know, the interveners and interests, Trump and the Republican Party of Colorado, where like, what, you're going to say that there's no recourse to removing Obama from the ballot if he were nominated by the Democratic Party? Really? Are you going to say that, like, what's the difference between qualification for age and natural citizenship in this? There's not good answers to those questions. And the historical evidence, in my opinion, largely favors the petitioners here. The only difficult question, I think, the most difficult question, is application of the engagement standard, is whether or not Trump actually engaged in insurrection. That, even though I think overwhelmingly he did, that's, in my opinion, a more arguable question, as opposed to the legal questions about whether this court can hear it. I'm not really fit to talk about the Colorado procedural issues. Those are, I'd leave that to Colorado lawyers. Although It sounds like, in my opinion, they have the better of the arguments too.
So to clarify, you think it's actually a tougher question to determine whether or not January 6th was an insurrection and Trump is an insurrectionist, rather than the question of does this apply to the president?
Yeah, does this apply to the president, is it self-executing? For me, those questions are easier in terms of how ridiculous it would be if it didn't go that our way. Another tougher question is the First Amendment one, is to what extent does Section 3 incorporate the incitement standards of the First Amendment? Does it apply to just speech or mere advocacy? Those are some tougher questions. But the ones about like self-execution and officer, those are just lame, man. I really think that what the meat and potatoes of this is the insurrection standard, the engagement standard, and maybe some First Amendment concerns.
So the original case in Colorado, the trial case, I think it lasted about a week. Do we have any idea how long this could, or should last in the state Supreme Court?
They got to decide soon, man. I mean, I forgot the dates by which the Secretary of State needs to know, but they've given a date on when they need the answer by before they need to start getting ready for the primary. And so it's soon. I gave a tweet about this. For those of you who follow me on Twitter, you'll know about it. Where I said it could come to the Supreme Court faster than you think, because this election is happening, I believe, in March. Let's get the actual date.
Yeah, Super Tuesday's in March.
Yeah, Colorado primary 2024. This election, the primary election, is happening in March 5th, 2024. That's just happening, right? And so think about it. For the Colorado Supreme Court to weigh on this issue and to have time for the Supreme Court to be able to hear briefings on this and decide this before the time by which the Secretary of State needs to prepare for the primary, that's soon, man. I don't know the date. I'm forgetting now the date that the Secretary of State gave as like the target date, but it's soon, because whatever happens, I'm sure there will be an appeal to the Supreme Court, and they need some time to deal with it before the cutoff.
Do you expect that the United States Supreme Court will hear it?
Yes.
You don't think they'll punt?
Well, I didn't say that. I said
Okay.
I think they'll hear it.
Okay.
I think they'll hear it because I think anything less than that would potentially cause chaos in the lower states. If they, like, let's say that they decide, Colorado says he's disqualified. How's the Supreme Court not going to hear it? Because you could have the situation where he's disqualified from Colorado and only Colorado, and then any other state that like takes the lead from Colorado and is like, look, they found that there and Supreme Court denied it. It looks like the Supreme Court probably agrees with Colorado since they denied it. And so we're going to do the same thing. And all it takes is like, someone in Michigan, someone like, and all of a sudden.
Well, it's funny you say that, because I'm thinking now, and of course this isn't a matter of law as much. Well, in this, it's a matter of law and politics, because I'm thinking you might have, if it doesn't look like the Supreme Court is eager to pick it up, you might have a Democrat Secretary of State force their hand and try to keep Trump off the ballot to try to prod
Assuming
somebody.
The Colorado Supreme Court,
Yeah.
I could see them not addressing it if the Colorado Supreme Court says he is qualified.
Right.
But even that might cause uncertainty.
No, and I think they're still going to be filing these suits, because it's not like suits have been filed in all 50 states. I know in several.
Sure. And when you have folks who have more standing grounds, so like let's say President Biden, once he becomes a nominee, and once Trump actually becomes the nominee, and now you have the general election ballots, and now we know in Minnesota they've already said that there's a state pathway to review. Does the Supreme Court really want to? Minnesota is a swing state, folks. Minnesota is a swing state. Are we going to be in a situation where the Supreme Court ducks a decision on this Colorado case and leaves it to the Minnesota Supreme Court to?
Colorado's a swing state. I mean, that's the other thing too. Yeah.
Yeah.
So actually, and it's funny too, you said standing, because now it occurred to me, because like the petitioners, they took the position that they don't, and I'm probably going to be crude with this, that they, in order for their vote to be properly counted, Donald Trump can't be on the ballot, essentially, because he's disqualified. Would President Biden, could somebody make an argument? I'm sure he wouldn't avail himself of this option, but could somebody make the argument that when it comes time for the general election, if Trump's the nominee and Biden's the nominee, could Biden make the argument he has standing?
Yeah, I think that he should have. I think that he should make the argument that he has standing. And I think that because he would obviously, would have an injury in fact if he has to go up against Trump, because he could lose the election. Just like, and I think that is about as clear a standing as you could get. And so I think that once they're both nominees, I don't know why President Biden could not open suit himself. And I think that if it comes to that, I think he should 100%. That's why I think if the Supreme Court cares about our democracy, they should answer this question soon. And I think they'll have to, or they'll be pressured to.
Well, and on that, so I need to brush up on this. I thought there were certain things that automatically fast-tracked for certiorari under the Supreme Court. Can the Justice Department, can the president, can somebody, is there any way to force the Supreme Court to hear a case, or is it completely discretionary?
There's some ways. So one is to use the Supreme Court's original jurisdiction. That's not a possibility in this case. That was what the Texas case tried to do, where when two states go off against each other,
right?
There's a provision in the Constitution that
only the Supreme Court can adjudicate.
Jurisdiction to sit as a trial court. So that's, I believe, I don't think that's discretionary. I think they have to hear. Ultimately, they obviously dismissed that for lack of standing. But that's one way. There are other forms. There are very few forms, I think, of mandatory review.
Mm.
But that said, one of the considerations that the Supreme for certiorari is like this kind of overwhelming public interest, and so it would just be horrible for me, regardless of the outcome in Colorado Supreme Court, if this is not appealed to the Supreme Court, for the Supreme Court not to address it in some way. Listen, I don't even necessarily think that on balance, if I were betting, that I would bet that the Supreme Court would rule in against Trump.
Our favor. Yeah, exactly.
I would think, right now I've consistently put it like 25 to 30% odds that they do the right thing, in my opinion.
That high.
Yeah.
Wow.
I mean,
I didn't realize you were such an optimist, Pisco. Yeah.
Well, the thing is, I think that this kind of argument was tailor-made to get some of the, this is so depressing to say, some of the swing votes on the court, including Amy Coney Barrett and Justice Kavanaugh. They're the swing votes, among others. It's mostly, I would say, Kavanaugh, Roberts. I think that Roberts would be leaning against disqualifying Trump.
Really?
To be honest with you. So I think that Amy Coney Barrett is a more likely vote to nab because it's just like a very originalist focused argument you can work with. And I think that Kavanaugh is up in the air in terms of that. But obviously, both of those justices, I would put lean.
Yeah, Alito
Trump.
and Thomas, they're gonna hug.
No matter what, those votes are gone. So don't even count on them. Roberts, I would say, is 50% to where Alito and Thomas would be on this particular case. And I think that your swing vote, and I think Gorsuch is right with them as well. So I think that your swing votes are Amy Coney Barrett and Justice
Brett Kavanaugh. So 2 questions on that, just to kind of wrap up the mandatory review. Again, I don't know the legal history, and you may not either. But if a sitting president is a party to a case that is how do you call it? Justiciable, I think.
If the United States is a party to a case?
Yeah. How likely, I guess what I'm saying is, if the president's name is on it, do you think the Supreme Court, basically if the president's like, guys, I want you to take a look at this, do you think that increases the likelihood, decreases, or has no impact whatsoever?
I think it increases. Now, the United States of America is not a party to this case. There's a way that which America can become can show up as kind of like a pseudo amici. The SG can like intervene in a case to argue it one way or another if there's like a compelling federal interest at stake. So even if they're not a party, oftentimes you'll hear the Solicitor General of the United States represent the America's sort of perspective and interest as represented by the president. So like in a lot of the cases involving the Affordable Care Act, or like sometimes other, go ahead.
Oh, is that Prologer? Is she the Solicitor General? Yes. Dude, she's a bad mamma jamma.
She's a really smart SG and a very good arguer. So I think it's possible the SG could intervene to argue it, but of course they're not a party to the case. They would just give their opinions of the United States of America. But like in terms of, I just think that this is very much a case that the Supreme Court would want to answer.
Fair.
If the Colorado Supreme Court comes to a decision disqualifying him or not disqualifying him and it's appealed, I think it's a very high likelihood that the Supreme Court will take the case. We'll either dismiss it or will rule on the merits of it or rule on some procedural issue. But I think that the likelihood that the Supreme Court takes the case is like 70 or 80%. The odds that they rule and disqualify, I think, is like 25, 30.
So we'll wrap up with a couple of questions that are actually off topic now. So the first one is SG, Surgeon General. Do you want to clarify? Yeah. And who that is, what that is?
That's like, I think technically the 3rd or 4th highest ranking person in the Department of Justice, but they're specifically for appellate arguments. And usually the Supreme Court, that's what they're most known for, is preparing for appeals to the Supreme Court, and the person who argues it.
So they're more of a litigator than an administrator.
Yeah, they're also involved in some kinds of policy, I think, but they're more focused on the America's position in appellate sort of postures, especially to the Supreme Court, and I think usually to the Supreme Court. And these are like repeat players, people who are very known in the Supreme Court bar, who have done arguments before. These are very talented lawyers. You have to be, and yeah, usually some of the smartest people in the Department of Justice.
Yeah, Elizabeth Prelogar, she was the one who defended, I think it was President Biden's student debt relief plan. And I remember she was so good, guys. She was
I'm still
so
mad about
good.
that.
Yeah, no, listen, she was so good that if you go back on Twitter, you will find right wing commentators singing her praises. These are people who hate Biden, hate the idea of student debt forgiveness, and they thought she kicked ass. That's how badass this woman is. Number one. So the other, the two things questions I had for you that are again off topic for this. Number one, we mentioned Alito and Thomas, and some of the comments in here, they're talking, of course, about some of the judicial scandals there. One of the things I enjoy talking about with you the most, especially when on Steven's stream, is we kind of like go around the outer edges of what I call constitutional tension between the three branches of government. Because what's fascinating is we talk about how the three co-equal branches, but there's almost at times like a rock, paper, scissors effect.
Yep.
And then it also depends on your interpretation because, you know, if you look at real originalism, if you really want to get technical, Congress was meant to be first among equals. It's the one with the fewest checks against it and the most checks deployed against others. You know, judicial review wasn't a thing in the Constitution. That was something the court, I mean, they say there's constitutional basis for it, and I won't dispute that, but it's not explicitly written in the
Not
Constitution.
explicit, yeah.
Right. So this idea, like even if you grant the idea of judicial review where they can strike down laws, well, in theory, the Constitution or the Congress can do an amendment, and the Supreme Court has no recourse against that. And
With the consent of the ratification of the states. But I
well,
understand.
sure, but you understand what I'm saying.
Yes.
Like, and so there's this idea that again, checks and balances co-equal, but Congress was intended to be first among equals. Then you say, okay, the imperial presidency over the past 100 years, the president was always going to be by far the most powerful individual actor, infinitely more powerful than a Supreme Court justice or a senator or whatever. But then over years, the executive branch has swelled. It is the biggest branch by far. It's the one with the most active authority, and Congress has deferred quite a bit of it to the president. But then you say, some people say, well, the Supreme Court, as long as people pay deference to it, the Supreme Court can strike down laws, executive orders. You talked about earlier how they can issue orders to the president, orders on paper. So,
But that they're loath to do so.
sure, because they know, well, they should know. And it was funny. The reason I'm talking with you about this is not just because you're an attorney, but I had a conversation. Do you know who Quid Pro Joe is in Destiny's
I
Reddit?
know very well.
Yeah. So he and I, we constantly go
annoys
back and forth. Yeah, I like the guy, but yes, he annoys me in a good way too. I enjoy bantering with him because one of the things that we talk about is, so there's the phrase, of course, Congress has the purse, the president the sword, and then the court has judgment, I think is what they say. Just they have neither force nor finance, just judgment. And so they require basically buy-in from both the other. They have to have legitimacy with the people
Very
and
true.
with the other branches. Here's my question. You know, right now we're in a situation where you have Samuel Alito, Justice Alito flat out said he does not believe, he told the Wall Street Journal this, that he doesn't believe Congress has the authority to regulate Supreme Court ethics. Now, Justice Kagan, I believe, disagreed, and obviously a lot of other scholars do too. But I was kind of blown away, not only at his utterance, but also how widely accepted it is right now among the Republican Party and conservatives. This idea that the Supreme Court, which consists of 9 unelected lifetime appointees, are not subject effectively to checks and balances from the other branches. Now, you are an officer of the court. You are an attorney. So my question is, I'm not, and I think to myself, I can't abide a court that is checkless. I can't abide that. There has to be practical ways. If you can check the fucking president, you should be able to check the Supreme Court. What do you make of the idea that Congress can't really interfere with the court in terms of imposing ethics on them?
I'm not sure I buy that premise by Samuel Alito. To be clear, there are some nuclear buttons that no one denies Congress can use. For example, for those of you familiar with history, there was an act by the Jefferson administration. I believe I'm not speaking incorrectly here. You guys can check me on it. But there was, after the Adams administration where Adams lost the presidential election to Jefferson, they passed what's known as the Midnight Judges Act, where they essentially created a bunch of new positions, filled them in like the last minute as the waning days of the Adams Congress and the Federalist Congress was closing off. They did all that, and the incoming Jefferson Congress, incoming Democratic Republican administration under Jefferson hated that and despised it. And for those of you familiar with Judicial Review and Marbury versus Madison, that dispute comes out of one of the justices of the peace who was appointed under the Midnight Judges Act by the Adams administration. And in response to that, as well as not delivering Marbury his commission, this is Secretary of State James Madison, who of course wrote the Constitution and is under President Thomas Jefferson. One of the things they do is they pass an act where the Supreme Court does not sit for a whole term. For a whole term. They shut the lights off at the Supreme Court to let some ink dry on rescinding some positions that they've legislatively undone with some later legislation that they tried to undo some of the positions that Adams had implemented. And so all this goes to show, and it's a long way of saying, Congress has authority to put the lights on the Supreme Court. Explicitly, Congress has the authority to make exceptions to the Supreme Court's appellate review. And no one really knows how far that goes. If Congress passed a law that says you will not have appellate review as to the constitutionality of this very act that we're passing, I mean, can Congress do that? It hasn't really been tried. It's been threatened before. And so there are some nuclear buttons. Everyone
George
hates it when I
Bush.
say nuclear.
Yeah, no.
Nuclear buttons that the Congress can press for sure. Now, and I'm not so certain that they can't impose some ethics rules on the justices, but I do think that obviously there's some practical limits on doing this, and so it is a little bit disconcerting, especially when the Supreme Court has made so many, in my opinion, bananas opinions as of late. But yeah, that's kind of
I guess that's and again, I'm being crude here because we could talk about this for 3 hours. So, but I'm just, please factor in, I'm speaking in the crudest terms possible just to quickly relay the point. The way my conception is of the three branches now is that it seems like the current Supreme Court is fairly inclined to fuck with the president, and President Biden is not so inclined to fuck with the court. And of course, I'm biased because I'm a Democrat and the court has a super regressive supermajority. But the idea that the court is uncheckable by Congress bother me, but also by the president. Because I also keep going back to, and this was a part of the conversation Quid Pro Joe and I had, like, President Lincoln, like the president that I respect in terms of his statesmanship above all else is President Washington, then President Lincoln. But President Lincoln is generally people's favorite president. And there were times he told the court to go fuck off. You and what army? You can't do shit. I'm more powerful than you. He flexed on the court. He didn't do it casually, but he did at times when push comes to shove, especially with respect to suspending the writ of habeas corpus. So we talked about the nuclear button that Congress has on the court. What other than non-acquiescence, basically the president saying no? What is there anything that the president can do to check the court that would deter the court from because I guess the way I phrase it to Quid Pro Joe is I feel like the court should be very nervous about intruding. Not saying that they shouldn't do it ever, but they should be very careful about intruding on the province of the executive or Congress. That the default assumption is we should try to make this work as much as possible and not go in direct opposition to one another. Mm-hmm. What deters them from doing that with the president?
I think that there are some personnel on the court who are deterred by. So I think Roberts, and specifically, is trying to. You could fault him for a lot of things, but I think that he's trying to keep the boat afloat, or the ship afloat, however you want to say it. And so the personnel on the court, at least some of them, I think limit themselves. There are a lot of doctrines that courts do abide by. I mean, they do abide by standing doctrine, clearly, at least to some extent. When I should say, there are people who disagree with me on that, but there are some self limits that the courts impose. If the court were to apply the political question doctrine in this case about Section 3, that's them limiting their own authority, right?
Sure.
A lot of the problems with, even if the courts rule, I mean, we're the ones asking for a judicial remedy in terms of the people who are saying he should be disqualified. And so the court, one of the barriers to the court's intervention is this doctrine which would limit their authority to review the scope of these
cases,
these rules and these applications, right? So there's a natural, even if they rule against us, they're doing so in a way that defers authority elsewhere. And so in this particular case, I'm not so worried about judicial overriding the will of Congress or the will of the executive, because we're asking for a remedy. We're asking
and that's why I'm saying, I guess I'm saying in general. Yeah, in general, because I think the perception I know of me, but also of a lot of people, Pisco, and maybe you share it, is this idea that you take the current iteration of the Supreme Court and President Biden, and it seems like this court is much more willing to defy the president than the president is to defy the court. And if they're supposed to be equals, why is basically, going to be very crude here, why is the president the bottom in this relationship when he's the one with the army?
I think a lot of these ones, the ones that are most flagrant, are like the student loan one.
Sure.
Some of the COVID restrictions where the language is very broad, but they don't defer to it. And those are cases where, like, I think that the court absolutely overstepped, and Congress wrote an overbroad statute with which the president used appropriately in terms of like his actual authority to do so. Those are the cases where I feel that they've overstepped, and where I felt that they really sort of inputted their own view on what the
judicial activism.
In terms of what, in terms of what the statute, in place of what the statute says.
Sure.
That said, some of the more controversial opinions that I disagree with the most is the court saying that, we're not going to get involved. I'm thinking right now of Dobbs and the overturn of Roe v. Wade. Say what you want about that opinion. It is saying that courts don't have the authority to hear those claims. And it's giving it, and I don't agree with it, but it is giving it to the states and to Congress and to the representative branches. So a lot of the more bad decisions, and for instance, one that I might envision in this particular case, wouldn't be judicial overreach in that.
So then you would say, again, as an attorney and someone who probably pays closer attention to these individual rulings than even I do, you would say even this court, more often than not, for every time they defy the president or stick it to the president, there's 2 or 3 times where they're like, "Nah, they
restrain themselves." And maybe I would say, arguably for political reasons, they restrain themselves a lot of the time. But let me just put it this way: I'm very worried about the state of our electorate. I'm very worried about, Congress is so dysfunctional. I'm more worried about the dysfunction in our political branches than I am about the dysfunction in the courts. Even though there's a lot of problems with the courts, I think that there's a lot of problems with the composition of Congress. And so, yes, there are things that annoy me and where the courts, I believe, overreach. Another one, I think, is some of the gun cases that they're going to be seeing, where they're sort of implementing their will for what the states say about, reasonable restrictions on guns.
Aren't they right now hearing a case about the wealth tax?
Yeah.
Yeah.
Again, but everyone is going to think, if they agree with a case and they want, the courts to come in and step in and overthrow the will of whatever act is done, the people who agree with that are going to say they're supporting democracy because they're enforcing the Constitution. And the people who disagree are going to say you're overriding the will of the people. And so that
And I hear, and that's the thing. I'm sensitive to that, and this is why it's so fascinating to me. And I've said this before. I've said this to Stephen. I've said this to others. Our system of government, the Constitution, the federal government, our system of federalism, all of these things are predicated on reciprocal good faith and the tension that it creates. These documents and these institutions are not divinely crafted nor divinely enforced. And that also, in a roundabout way, goes back to show how dangerous Trump is, because people say, Stephen, as you know, is about to have in a month or so. He's supposed to be having 2 months that debate with Ben Shapiro.
Right.
And one of Ben Shapiro's arguments, gang, my wife's a doctor, gang, is one of the things he says is, Trump, the guardrails held. And I think it's such a shitty argument, this idea to downplay the threat Trump poses because he didn't succeed the last time. And I've been saying this, I said this to PF Ewing yesterday. We don't, after a guardrail has been warped and twisted by a car accident, we don't just remove the car, ignore the guardrail. We repair, reinforce the guardrail, and we don't toss the fucking keys back to the person who ran the car into the guardrail in the first place and just assume, well, it'll hold this time because it held the time before. That's asinine. It's predicated on good faith, and you can't bad faith proof a system of government. You cannot do it.
Yeah,
and
true.
so that's why I like talking this stuff about the tensions that exist, like who's on top between these three different branches, because I remember, and it wasn't a Supreme Court issue. Do you remember when I think it was misoprostone or that abortifacient drug? Yeah.
Yeah.
Mifepristone. Yeah. There was like a national hold on it by that one court out of fucking Texas.
Yeah.
And AOC, and I'm sympathetic to this. You may disagree, but I'm sympathetic to this. AOC is like, okay, if that's how we're going to play it, Biden should pull a Lincoln, non-acquiescence, say you and what army, and order the FDA to keep distributing this abortifacient. And I understand. But my point is, the reason I'm sympathetic to it is because we can't have a situation where the court always wins. To me, that I don't think that's what the framers intended, where one branch is always supreme. There are times that the court, that the president, that Congress have to take their lumps, take their defeats, and it seems like, and maybe this is the perception this is a misperception. I feel like in recent times, we're getting these high profile examples of because Biden doesn't threaten to court pack. Biden doesn't threaten to do this, that, and the other. He finds creative ways to leverage other authorities, like after the student debt program was shut down. He used another program, and he's brought billions upon billions upon billions of dollars of student debt relief, which is great. And I do agree that is preferable. That's preferable to outright defying the court. I don't know. I don't feel like we can concretely identify. I don't think there's a way to bad proof this system and bad faith proof this system, rather. And I feel like that's an example of that.
I mean, I agree. I think that if you have, it's hard to say this, but like nothing is going to fix bad people, right? Like you could have the best institutions in the world. If everyone you elect is a scumbag and everyone in power is bad, like it's not going to fix it. So I agree with your central thesis. I don't necessarily agree that we're there yet. There are some things that the court could conceivably do where I'd be like, okay, you can't listen to the court to do this, right? Because it would mean the destruction of our democracy, or it would mean this or that. But I would view the defiance of the Supreme Court as like a major step. That the moment that we do that for over mifepristone, that's a battle you can win eventually.
Fair.
But the minute we do that, then you're opening the door to I do think you're opening the door to a whole can of worms that will be used against you, and you will have no basis to fight it, or you'll have less basis to fight it. And so that's like a tool in the tool belt in terms of defying the court that you only break in the case of imminent, dire end of democracy, end of days, end of.
You're right. I just feel like occasionally Biden should point at it and say, "I still got this one." I don't know. I just get the perception that this court feels like it's untouchable. I really do get that impression. They just passed, finally, that toothless code of ethics, Pisco, which I suppose you could take as a victory because they finally folded to pressure of some sort. But God damn, it's taking that much pressure for you all to say, hey, listen, yeah, we can't be corrupt pieces of shit. We have a code of ethics here, just like everybody else. We'll finally put pen to paper. That's insane, man. It's insane. I don't know. I feel like the other two branches need to scare the hell out of this court.
You say it's insane, and I understand that. But what would be insane to me is if like Congress, without impeachment, could get rid of a justice because they determine that they violated some ethical rule. Like, think about what they're doing now with the impeachment case. Do I trust Congress to
No,
enforce.
no, I'm with you.
Hell
I'm
no.
with you. This is the tension. This is what I mean. But
Do I trust Trump to do it? No, I don't. And like that's why I think dispersing this power, however uncomfortable it is in like the moment, is a source of strength. And yeah, it's like annoying a lot of the times that you can't have enforcement of certain things. Yeah, like you just can't. But the alternative is like, okay, Speaker Johnson is the one who's enforcing ethics rules on the Supreme Court and telling them what they can rule on and what they can, and I do that. To me seems horrible. Or like a President Trump or a President whatever. So I'm concerned about the I'm concerned about the long game here. Mifepristone, Dobbs, all that stuff. Totally understand the problems with those cases. Student loan stuff. I have a shit ton of student loans. In terms of my law school loans, I understand the frustration. I understand the pain that you guys feel when you see the Supreme Court do something bad. Although keep in mind, on a lot of these structural issues, the Supreme Court has kind of kept the rails on. They did not bite on a lot of the Trump election stuff, a lot of the Trump immunity stuff. I do not expect them to bite on the Trump absolute immunity argument he's doing in what's it called, in the DC case.
yeah.
And so structurally, yes, a lot of this stuff is scary.
Well, he suffered two back-to-back defeats with that. He suffered both. They found that he is subject to civil liability and criminal prosecution. It was Chutkin, and then it was the appellate court.
And let's be even more clear. The independent state legislator theory, the question about the Voting Rights Act, these are all like kind of structural components, I would say, of our society that the Supreme Court, as close as some of these decisions have been, some of them have not been that close, and they've kept the guardrails on. And so I think they're a useful institution. Do I agree with the Supreme Court on everything? Not even close. But didn't Roberts trash? No, I'm not.
No, I hear you. I suppose it's just me venting. Although I still think I would stand by some of it, even if it's at 1 p.m. and I was fully caffeinated. But Roberts gutted, he gutted the pre-clearance provision of the Civil Rights Act, which, which I mean, that's huge. That's taken one of you have a chair that's taken at least one leg off the chair. I mean, it's wobbly now. They're going after, I think, Section 2, a court, a conservative court held. It was a 3-judge panel that basically only the Justice Department can sue under Section 2 concerns instead of, citizens or whatever. That was the avenue by which we gained so much by way of civil rights and voting rights in this country, was the fact that allowed you and I to file lawsuits under that. And now this actually, no, the language of Section 2 clearly indicates that it's only the Justice Department can bring these suits, which means if you have a Republican Justice Department, they're never going to fucking bring a Section 2 voting rights, provision or voting rights lawsuit. And that's why I don't know. I am very much concerned at the current state of affairs in this country, with Congress, with the courts, with the presidency, sometimes in the hands of a Democrat, also in the hands of a Republican, because, sometimes I want Biden to at least gesture in the direction, just to rattle the saber of a more radical decision. Like, this idea that the Supreme Court,
don't go to the dark side, Luke. The reason
yes,
why Biden has been, I think, such a breath of fresh air, and people might look like, what, breath of fresh air? It's business as usual. No,
he's 80 years old, Pisco. This man has not been fresh.
I know
it sounds 70
so
years
ridiculous for me to say breath of fresh air, but to know that there's someone who values what this country is about and doesn't do that and restrains himself, that's a sign to me that there are some politicians who are willing to defend what historically I think this country has been excellent at, and why it's endured so much is because there has been moments of good faith. And so I don't despair at this. There have been other times where we've been challenged by courts that have done crazy things. Never forget that you could arguably say that a Supreme Court decision brought about a quicker start to a civil war. Maybe you could say that the Civil War is inevitable, but Dred Scott, that was this court. That was the Supreme Court of the United States. There are a lot of horrible decisions in the court's backyard. Korematsu, to say nothing. Time moves on, and don't ever give up the long game, and use short-term political ambition, which undermines and sets up for a defeat and the destruction of our democracy. I understand your frustration. I understand that there are different standards for sure. I've heard you say it all the time in terms of the Department of Justice and what, the thing about the kind of standard for the corruption, I would sideshow total distraction lies that are being spread by the impeachment inquiry folks in the
For the record, for those of you who don't know, Pisco is as outspoken as I am about this fucking impeachment, constantly calling shit on it. But anyway, go ahead.
Yeah, and your videos have been so awesome in just totally destroying them. The different standard that Biden has placed compared to Trump in terms of like conduct that doesn't even compare is insane. And you will go crazy thinking about it all the time. But that's the price we pay for defending our democracy and for being, I think, advocates to this tradition that has endured and should continue to endure.
Got two more for you. So one here, there are no guardrails after the Insurrection Act, says Jeffrey Jones. I do want to point this out. I did read an article, and it was from the source. It was a Reuters article, and it was a Brennan Institution lawyer who says that apparently it's a scholarly consensus, and I could be misrepresenting this, but I'm pretty sure I have it right, that the authority granted to the president under the invocation of the Insurrection Act is not considered subject to judicial review, or at least has not been in the past. And from my reading on it, it's, the Insurrection Act as we know it today basically has its origins arguably in the Militia Act under President Washington. And it was a law built for President Washington. It was basically like, hey, if you have to break this glass, here's basically sweeping executive authority. But we trust you, statesman George Washington, not to break this glass unless you absolutely need it, and you'll put it back together. And then it was effectively codified again that way under Thomas Jefferson, et cetera, and so forth. And now you have Donald Trump, who is the least statesman president in the history of presidents, saying he'll break that glass, and it's not subject to judicial review. Does that not scare you?
Of course. I think that I don't know that our country would be able to survive a second Trump term. I think that it is imperative that Joe Biden, or whoever the Democrat candidate is, if it's not Joe Biden, though I expect it to be Joe Biden, win the election. Trump cannot win a second term. That said, even if he does, I'm going to stand by here and fight. This is a country I love. I'm going to fight for the country in terms of making sure, or trying to make sure, that we maintain our democracy. And I'm not going to advocate for the use of violence or illegal activities,
no, of course
or
not,
anything like that. If it, and I don't think that you were advocating for it, but lawlessness or corruption, really, which I think it would be corruption if you say that in the face of the threat of Trump, we break the law or we ignore the Supreme Court, that kind of thing. I mean, because you can make the same argument like, well, he's such a threat, why not just arrest him? And
sure.
So I understand the threat. It's an existential threat. One of the reasons why you hear me being so vocal about Trump's corruption in these cases, because not only do I believe everything I write about Trump, and I do think he's fascist, is because he is a threat. You're not wrong about that assessment. We just need to be calculated and sober about our response to it. It needs to be sort of calculated to be the best possible outcome. And I think that getting hysterical, not that saying that you are being hysterical, but getting hysterical is the wrong move here.
So then another one here, Blonde Philosophy. It's not so much that the court should be checkable. It's the court is being used politically, and appointments are more political than it has ever been before. It was never meant to be political. Anything to say to that?
Yeah, I would say yes and no. As always, I totally agree with Blonde Philosophy that the courts were supposed to be, they're insulated from politics intentionally. That's the point of the lifetime tenure for good behavior. That's the point of separating it out for the nomination process, to have one body assent to it with advice and consent. So I totally acknowledge that was the purpose on it, and the specific protections from political interference for sure. That said, part of the nature of our democracy is that everyone has to have some connection to the people, and there is an innate political connection to the president by virtue of his appointment and the approval by one of the most political branches that there is the United States Senate. In this day and age, you could argue, right, that the nomination process and appointment for the Supreme Court specifically, and really for all federal judges, has become more openly political. And the senators don't even like try to hide it with their questions anymore. And the justices at this point, sometimes they don't even try to hide it. And so part of our culture absolutely is contributing to the loss of independence and legitimacy in the eyes of the people with respect to the courts. And I do agree that they were meant to be a little bit more insulated than they are today, though I don't want to discount the fact that the courts have to be answerable to the people in some way. And that's
yes. Yeah.
Point.
Otherwise, we might as well say like that. I guess that's my point. Is they have to be. They are 9 lifetime appointments. You could make the argument that this branch needs the most checks, depending. I mean, it depends. It depends on what your prism is. But this idea, otherwise, the court is supreme, and we should just say it's not 3 co-equal branches. It's a triangle, and they're at the pinnacle, and then, or it's a straight line where it's.
I mean, I understand what you're feeling. I just think that
Yeah.
I'm much more scared about a president gone hayward than I am about a.
Sure. I hear you. Because again, but so much of that PISCO is because their enforcement requires the other branch. It's because at any time the president could turn to the Supreme Court, which is the least popular of the branches. It's less popular than Biden. It's less popular than Congress. The president could go, fuck off. I completely understand that. I'm just saying like that. That's what I mean is that the court does have to be answerable to the people.
Sure.
The court should, I feel like the Supreme Court should be nervous at all times. I feel like I'm not saying that they should never rule.
I think that in many ways they are. I think that
Yeah.
they're nervous. That's one of the reasons why I'm like,
they should have ulcers at all times. Like they should be like
They're
breathing
all
in the bound. It's like,
but
no, Thomas isn't. Thomas doesn't have any ulcers. Let me tell you, because that man's on a yacht. He's just hanging out. He's. Oh,
even
do you
Thomas? I don't think Thomas is even though he's I would say, he's gotten the opportunity to write up some important decisions recently. He is not the judicial center of this court, and if he wants to sort of impart his doctrine and to have these decisions, he also needs to be aware that not everyone agrees with him, even in the conservative side. And so there are things that limit even Justice Thomas.
Okay. Very last question. Brianna Joy Gray said in 2016 famously, and I very rarely punch left, rhetorically speaking. I usually just pick on the right. But since we're talking about the election and the potential threat posed by Trump or a rogue president or a rogue court, Brianna Joy Gray famously said in 2016 when people were saying, listen, vote for Secretary Clinton over Donald Trump because the next president may be able to pick 1 or 2 Supreme Court justices. Mm-hmm. And she said something to the effect of, you're overstating the importance. Yeah. So can you just, you get the final word on this. Can you just give your thoughts on this?
Yeah, it is vital. People who advocate for not voting for Joe Biden and the Democratic nominee, it's a kind of nihilism that I can never understand. I mean, here is everything I hate in the form of Donald Trump in the sense of what he represents, not as necessarily even as a person. I actually find Trump in many cases funny. He's actually pretty funny of a guy, and he even had some good policies. There are some policies that you can point to of Trump's that were good. And so I don't
First Step Act.
I don't discount everything that Trump does or even who he represents. I even think that Trump could have been a very good president. He had the opportunity to be an extremely consequential president.
He just had to be a completely different person.
No, yeah, I know, but think about it. Here's a person who is a populist, but he could have channeled that for a new age to the Republican Party. He could absolutely have built his wall, but provided some kind of deal with Democrats to have a pathway to citizenship for certain people, for DACA kids. He could have been a real deal maker. He could have been, infrastructure guy, and he would have had willing negotiators on the other side, and he even had a majority in the Congress for many times. He could have been an extremely good president. But it's not that I hate who he is innately. It's what his values are, what he represents, in my opinion, is the death of this country and of our democracy. And that's everything I love. And so if you are doing something that's going to materially benefit his odds of doing that, in a way, it's a kind of nihilism that I see. And so I do not agree at all with Brianna
Joy Gray.
Joy Gray on that in the slightest. And especially for the Supreme Court and the courts are concerned, you're going to hand over, the minute you have a Republican president, Alito, Thomas are both going to resign, and you're going to get an incredible all majority for the rest of your life, on the Supreme Court to be doing all sorts of crazy things and striking down all sorts of, you want a progressive agenda? This is going to guarantee that it will never, ever happen. Or you'll have a confrontation between the branches that you're sort of alluding to, Josiah, and it'll end democracy in another way because our institutions will crumble because, the populist socialist base that you just believe exists in this country, that is just waiting for their champion, they'll be so mad that they'll tear it all down. And so I totally think that people need to wake the fuck up, and get with the program, because, and I'm sorry that sounds harsh and that sounds kind of domineering over your decision. Ultimately, it's your choice. But if you love this country and you want to see it thrive and you care about progressivism, there's only one choice.
Yeah, I hate to say it. Actually, no, I don't hate to say it because it's absolutely true. Believe it or not, an anti-vote, as in like you're voting not in the affirmative sense for a particular candidate, but you're voting against the other candidate. No, a vote's a vote's a vote. It's equally valid. It weighs just as much. And the lesser of two evils is a perfectly valid heuristic. Harm reduction is a perfectly valid ethical prism. 100%. You don't have to be in love with Joe Biden. You don't have, and by the way, you'll notice in my recent videos, folks, I don't even necessarily say Biden with respect to the 2024 election, because this dynamic applies to whoever the Democratic nominee is. If you're an eligible voter in this country, you should vote blue in November, period. The Republican Party cannot be trusted. They're an authoritarian cult of personality with no limiting principle, and they need to lose they need to set some elections out. They need to lose just a couple of games. You know what I mean? Just like a couple of championships, just a good reset, and then we can go from there.
Can I give you an analogy? And I struggle with this analogy because, and I know we've stated it already, and everyone who's watching, I'm sure, agrees, but I just have to get it out of my system. I think the people who, like Chris Cuomo, who I heard the other day, I don't know if you heard that, they're just not calculating the danger. My dad, he used to tell me, because we would always question him, and I think that it's important to question your parents and question authority. I'm a super skeptic, cynical person myself. If you ask anybody I'm close to, I'm always questioning, like, wait, what are you talking about? There are times in your life where if you get a call from someone you know and trust and say, listen to me, Pisco, listen to me, Josiah, there's a bomb coming your way. You need to get all your clothes in the car, pack up right now, just grab this box and get in the car and get out of here. There is not time for you to say, well, is there another option? No, you got to go. And that's what we're facing here. We're on the ship, and there's only room for one pilot, or one, plane, only room for one pilot. And we need to land this plane. I mean, that's just the truth. And you're going to hand the reins to this guy, because of what? Because of a year of inflation.
Stick it to somebody else.
Every other country faced worse than America. America was a leader in terms of its recovery on inflation because of trends totally outside of the administration's control. You're going to throw it all away?
And not to demean this, or even legitimate disagreements that you have with certain aspects of foreign policy, 100%. That this other person would handle 10,000 times worse.
100%.
You guys know what I'm talking about. Yeah.
I'll say it directly. I believe in the establishment of a Palestinian state. 100%. I am with you on that. And I truly believe that what is happening in this conflict is horrible. And it's, of course, informed by a context of ignoring a problem that's been festering for decades. You think that you're going to be helping any Palestinian or anybody in that area by allowing the guy who moved the embassy to Jerusalem, the guy who, just look at the words they're using about the citizens.
Turn Gaza into a parking lot is what his party's saying.
No. This is abhorrent. We need to stabilize this ship, and I'm sorry that you have this choice, but you do, and there's only one option. And we've talked too much, and I have to start getting ready to go. But it's been so amazing talking to you, Ruminate. We should do it again sometime.
100%, dude. Especially because this.
Oh, did I say Ruminate? I'm sorry, Josiah.
Okay. That's right. I rebranded. I'm Josiah now. Oh no, dude. I appreciate this because everybody's been asking about the 14th Amendment. I'm more informed than most, but I'm not an attorney, so I think it was important to get somebody who actually had legal training to go through some of this. And we will definitely do this again, and obviously just talk politics. Period. And you and I will continue to pressure and bully Steven to the extent that we can to do what he does. By the way, guys, DGG and Destiny's Community, they're doing this whole, it's public knowledge, this big epic canvassing operation next year. I can't speak for Pisco. I know I will be at certain points canvassing and door knocking with them and anybody else because this shit is so important. We have to get this right. So
yeah, I'm talking to people about getting involved as well. It's an all hands on deck thing. And again, sorry to sound like a shill, but it's because I love this country and I want it to continue.
Yeah.
And also, I voted for Bernie in 2016 and in 2020 in both primaries.
There you go. He's
got
his progressive bona fides.
I have a black friend kind of argument, or I have this, but it's true. Okay. Yeah. I promise you. The only option that Bernie would ever endorse, I think, or the progressive, the true authentic progressives in Congress would endorse is a vote for the Democratic candidate.
He did. He flat out explicitly endorsed. He got so much shit from it when this was months ago, 6 months ago, he openly endorsed Biden. So anyway,
yeah.
Listen, I appreciate this. We'll definitely do this again. Thanks everybody for their questions. We'll do this again with Pisco soon. You all have a wonderful, wonderful evening.